matter.
Fresh matters ಕೊಡಿ.
Fresh matter after tomorrow. After tomorrow. Great.
Return of document. Yes.
Your Lordship, serial number 50, Your Lordship.
Huh?
Serial number 50, final hearing first matter.
The other side should be.
I have
present.
informed Your Lordship. Yes, government advocate, other side is also here. In fact, I was directed to produce a government order of the year 1994. Your Lordship, I have preferred application even to the another department. I will be requiring another 2 weeks time, Your Lordship, to produce that document.
54.
50, Your Lordship, 50.
Sanjeev Kumar.
Yes.
Serial number 50, at the request of learned counsel for the appellant. Release this matter.
25th, if I may request you.
Huh?
25th.
25th.
Yes, Your Lordship.
4 weeks ಆಗೋಯ್ತಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಸಿಗ್ತಾನೆ ಇಲ್ಲ ನಾವು ಪದೇ ಪದೇ ಕೇಳ್ತಾನೆ ಇದೀವಿ ಅಪೀಲ್ನು ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ RTI ಅಲ್ಲಿ. It is yet to be noticed, is yet to be issued.
25th of November.
Gratefully.
My lord, serial number 56, my lord.
Yes.
My lord, I am appearing with the appellant, my lord, serial number 56, my lord. May I have a request to have it on 11th or 14th of this month, next month, my lord. I am appearing along with Mr. Sudarshan, my lord.
It's a batch matter.
Two matters, madam. There are two matters.
Sagar Patil is there. Mr. Kalaburagi is there.
No, my lord, Kalaburagi, myself and Sudarshan are appearing at the same parties, my lord.
What about Mr. Sagar Patil?
Five, six.
But it's a connected matter. Let us see. They are not present here. We will see. Yes.
Much obliged, madam.
Serial number one.
Serial number 35, my lords. Kindly have it next week. It's hearing in hearing on IE. Serial number 35. I have informed the learned SPP also. 35.
You filed objections?
No, my lords. Next item.
Serial number 35, at the request of learned counsel for the appellant, release this matter
Next week.
on
On 6th.
6th of November.
Please.
Yes.
Non-compliance of office objection for first time, serial number one. Ganesh Subhash Chandra Kalaburagi.
2 days time, Your Lordship.
2
days time.
Time is granted at the request of learned counsel for the appellant for compliance of office objections.
Serial number two, additional government advocate.
Serial number 2 and 3, my lord, 2 weeks time may be granted.
Finally, 2 weeks are granted at the request of learned government advocate for compliance of office objections.
Please.
Serial number four, DP Ambedkar.
30 weeks time will be granted, man, while we comply with it.
A week's time is granted at the request of learned counsel for the appellant for compliance of office.
Non-compliance of office objection for fifth time, serial number five, Veerangoda Mali Patil.
Time. Finally, a week's time is granted for compliance of office objections.
Serial number six, additional government advocate.
Lord, finally 2 weeks may be granted. Finally 2 weeks, my lord. Serial number 6, my lord. There are
Fifth time.
part ಮಾಡಿದೀವಿ, but again they raise the objection for that is the reason.
Finally, a week's time is granted at the request of learned government advocate.
Please.
Order serial number seven, VD Angarki.
Finally, a week's time is granted the appellant to take steps for service of notice on the proposed appellant.
CL number 8, Ganesh Subhash Chandra Kalburgi.
For the appellant, your lordship. On the last date of hearing, your lordships, the matter was taken up in the chambers, your lordships. The other side house took time to respond to the petition. But it is the wife's appeal, your lordship.
Yes.
Yes.
Where is that? Where are the parties?
My party is present, your lordship. I'll call her. My party is present, your lordship.
The wife,
Wife.
Really, where the other side?
We passed over.
Chaitanya Kumar,
Aruna Kumar CM, Sudhir Kulkarni,
pass over.
CL number 9, additional SPP.
Capital punishment has been awarded to the accused, my lords. The copy has been served. Can it be posted next week's month? Objection is to be filed.
A week's time is granted at the request of the learned additional SPP to file objections to IA number 1 of 2024. In criminal appeal number 200176 of 2024.
And also, my lords, there is a direction by this honorable court. The order is dated 27/8/2024. This honorable court has directed the state to prepare, to file the status report insofar as respondent number, accused number 3 is concerned. His case is going on in Juvenile Justice Board. So this honorable court had directed to file a status report with regard to that also. So my lords, that also,
It could be posted.
it could be posted on a particular day with direction.
And to file a report in respect of
Accused number 3,
accused number 3.
Who is said to be the juvenile.
juvenile. So reported that. So on short date, my lords,
Release this matter. 6th ಆಗ್ಬೋದಾ?
No, my lords.
7th,
Next, 11th would be
11th of November.
I'm grateful.
CL number 10, Lepa Yerur, of habeas corpus petition.
This matter, my lord, was directed me to file the status report, my lord. We filed the status report, my lord.
The
ಹೇಳ್ತಾರೆ?
date of the status report is the date of my lord's order.
Huh?
The status report date is the date of my lord's order. Lord, a week is passed thereafter. Don't know what has happened.
Yes, further statement also, status also, my lord, filing.
Mother of the victim is present. The mother of the victim is present.
May make submission, my lord.
Yes,
Lord, last occasion, my lord, same complaint was given by the my lord parents.
yes.
Then, my lord, we traced, my lord, that girl and brought, my lord, to this. Then she only given the voluntary statement before the magistrate. Then, my lord, we filed the B report. But again, my lord, the same person that is gone and making the same allegation, that boy and parents. Now, my lord, she became very careful and taken the intellectual, my lord, mobile is also switched off and the SIM is also changed. But we are tracing, my lord, everything, my lord, we stated in
What
the.
about that boy?
That's why, my lord, he is residing at Kurnool, my lord. Kurnool.
Karnool.
Oh, Kurnool.
Ah.
We went there also, my lord. He is not there. And we also inquired with the parents also. We issued the notice also, request notice also we issued to the parent. But his father is not feeling well. Mother, my lord, we are requested to attend the police station. Kindly see the, my lord, that notice is also issued. Or page number 47, my lord. The status report, first status report. First status.
Page number?
Page number 47, my lord. by invoking my lord section 41(1). Or even that, my lord, page number 65 also, my lord. Or constable went for the, my lord, searching that girl and she submitted the report. She went to the Adoni also. This is the progress, my lord. The investigation is progress, my lord. If the parents of the girl is cooperated, my lord, with the police, definitely will trace, my lord. Here, my lord, second time, my lord, she gone. That is a problem. First time, my lord, with the same boy, my lord, she gone. And there is also, these parents, my lord, made the engagement, that minor girl. For that is the reason, my lord, she escaped from the home. She is not willing to marry, which is engaged with the boy. But second time, my lord, they forced to marry, that is the out of the record, my lord. For that is the reason, my lord, she gone.
Marriage ಆಗೋಗಿದೆಯಾ?
ಇಲ್ಲ engagement ಆಗಿದೆ. Engagement ಆದದಕ್ಕೆ, that is the problem, my lord. She is not.
If
They don't belong to the same community?
no, my lord, my submission kindly. If there is a material, as my learned AG has submitted, that engagement has taken place, I will be grateful if you furnish the information. Number one. Number two, with all that, my humble submission to my lords is, if the parents of the accused are summoned to the politician, that will survive my problem. Last time also I made submission, today also. That is all my submission. Last time when parents were summoned to the politician, the accused has brought the victim, minor victim, and they have surrendered. Today, if this is all done today, I think my problem will be addressed.
ಅದೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಂತಲ್ಲ?
ಮಾಡಿದ್ದಾರೆ, notice issue ಮಾಡಿದ್ದಾರೆ. My lord, this is all only for creating the records. It is only if they are summoned locally, they are there only. Parents of the accused are called. That will suffer. Even halfway they reach the politician, the victim will be, Lord, brought to the politician. Last time very same thing happened. Today also, my lord, my very same submission. Victim mother, Lord, day and night she is spending without any Lord, restless food, cloth, shelter.
Lookout notice ಅಂತಾರೆ. ಅವರ accused ಮೇಲೆ whether 41A notice is issued to the accused.
That's why, that is the notice I read, my lord, that even.
Notice, no, that is,
I'm sorry.
Notice.
in that 41A, 41A ನೇ.
ಹೌದು. That is which I referred, my lord, page number 47.
ಇದ್ರಲ್ಲಿ ಪೆನ್ಸಿಲ್ ಬರ್ದಿದ್ದಾರೆ. ಪೆನ್ಸಿಲ್ ರೌಂಡ್ ಆಫ್ ಮಾಡಬೇಕು ಈ ತರ. ಈ ಹಳೆ ಪೇಜ್ ನಂಬರ್ 50.
41A, 47 page number, my lord. To all the, my lord, 3 persons who are party before lordship.
Page number 47 is a letter written to the Commissioner Municipality.
This is the, my lord, B report, my lord, submitted last occasion. C given the same complaint, second time notice. That is C accepted.
That B report is not relevant.
That is not the, my lord.
Now
C-
she is a minor.
Oh.
You have to make efforts to
Although that's why, my
secure
lord,
her.
we are making the effort, my lord, as per the day to day also, my lord, we.
ಇನ್ನೊಂದು ಪೇಜ್ ತೆಗಿ.
Father of the victim is admitted in hospital.
ಹಾ
Father of the victim is admitted in hospital.
ಹಾ
And if the accused parents are summoned, that will solve the problem. Last time also same thing happened. They know each other, where their movements also they know. And also they are funding them.
So you have issued notice under 41A
Yes, my lord.
even to the parents
Yes, my lord.
of the boy.
Yes, my lord. Yes.
Then what did you do?
But that even is stated in that, my lord, in my diary, my lord, that is kindly see, my lord. In the status report.
ಅಲ್ಲ ಇವ್ರಿಗೆ ಅರೆಸ್ಟ್ ಮಾಡಿ ಇದು ನೋಟಿಸ್ ಕೊಟ್ರಿ ಬಟ್ ಅರೆಸ್ಟ್ ಮಾಡಿ
ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ ಅಂತ
Allah, kindly see, my lord, page number 4 of the status report, my lord. That is the.
ಇವತ್ತು ಹಾಕಿರೋದು
ಹೌದು.
ಇವತ್ತು ಹಾಕಿರೋದು
ಅಲ್ಲ, ಮೊದಲದು.
ಏನ್ ಹೇಳಿದೀರಾ?
ಠಾಣೆಗೆ ಬರಮಾಡಿಕೊಂಡು ಪ್ಯಾರಾ ಮಲಾಡ್ 4 ಮಲಾಡ್.
ಹಾ
ಪ್ಯಾರಾ 4 ಮಲಾಡ್. In the first report, ಮಲಾಡ್, page number 4. In our report, ಮಲಾಡ್. First report of the page number 4, ಪ್ಯಾರಾ 4. ನಂತರ ಸದರಿ ಪ್ರಕರಣದ ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್.
Second.
Page number 4
Yes, Lord. Para number 4.
is the communication dated 21/10/2021.
Status report.
Ink page 7, ink page 7.
Status report.
ಅದರಲ್ಲೇ page number 4.
Oh.
That is what we are saying.
ಅದರ ಮೇಲೆ
ಪ್ರಸ್ತುತ ತನಿಖೆಯ ವಿವರವಾದ ವರದಿ.
Ink page 7.
7 ಇದೆ.
Ink page 7.
Huh?
My lord, ink page 7.
7.
Ink page 7.
7.
ಹಾ ಹೇಳಿ.
7 ಅದು. ಪ್ಯಾರಾ ನಂಬರ್ 4 ನಂತರ
ಹಾ.
ಸದರಿ ಪ್ರಕರಣದ ಉಳಿದ ಇಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಹಾ ನಂತರ
ನಂತರ ಸದರಿ ಪ್ರಕರಣದ ಉಳಿದ ಆರೋಪತಿಗಳ ಕುಬೇರ್ ತಂದೆ ಯಲ್ಲಪ್ಪ ವಯಸ್ಸು 20 ಸೋ ರಾಯಚೂರ್ ಅವರನ್ನು ಬರಮಾಡಿಕೊಂಡು ಬಾಲಕಿ ಭೀಮವ್ವ ಮತ್ತು ಆರೋಪ ಅಜಯ್ ಕುಮಾರ್ ಅವರ ಬಗ್ಗೆ ವಿಚಾರಿಸಿ ಯಾವುದೇ ಮಾಹಿತಿ ಇಲ್ಲವೆಂದು ಹೇಳಿದ್ರಿಂದ ಸದರಿ ಆರೋಪರಿಗೆ 35(3) BSN ಅಡಿಯಲ್ಲಿ ನೋಟಿಸ್ ನೀಡಲಾಯಿತು. ಅಂಡ್ ಮಲಾಡ್ ದಿನಾಂಕ 6/8/2024 ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದಿಯರು ಅನುಮಾನ ವ್ಯಕ್ತಪಡಿಸಿದ IMVI ಸೋ ನೇತುಗಳಲ್ಲಿ ಯಾವ ಸಿಮ್ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತದೆ ಎಂಬ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡುವಂತೆ ಮಾನ್ಯ SP ಸಾಹೇಬರಿಗೆ ಪತ್ರ ಬರೆದುಕೊಂಡು ಅದರಿಂದ ಸ್ವೀಕೃತ ಪತ್ರದ ಮಾಹಿತಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ನೋಡಲಾಗಿ ಸದರಿ ಸೋನ್ ಯಾವುದೇ ಸಿಮ್ ಕಾರ್ಡ್ ನಿರ್ವಹಿಸುತ್ತಿಲ್ಲ ಅಂತ ಮಾಹಿತಿ ಇರುತ್ತದೆ. ದಟ್ ಈಸ್ ನಾಟ್ ಯೂಸ್ಡ್ ಬೈ ದೆಮ್. And 28 ಮಲಾಡ್ she went to the Sirwar. ಭೀಮವ್ ಈಕೆಯ ಪತ್ತೆ ಕುರಿತು ಮಾಹಿತಿ ಸಂಗ್ರಹಣೆ ಕುರಿತು ಸೋ ಅವರು ಸಿರ್ವಾರಕ್ಕೆ ನೇಮಕ ಮಾಡಿ ಕಳಿಸಿದ್ದು. ಸದರಿ ಸೋ ಸಿರ್ವಾರಕ್ಕೆ ಹೋಗಿ ಪೊಲೀಸ್ ಬಾತ್ಮೀದಾರರು ಕಂಡು ಬಾಲಕಿ ಮತ್ತು ಆರೋಪಿ ಅಜಯ್ ಕುಮಾರ್ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ ಯಾವುದೇ ಮಾಹಿತಿ ಸಿಗದೇ ಇರೋದ್ರಿಂದ ನಂತರ ಸಿರ್ವಾರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿ ಅಪರಿಚಿತ ಮತ್ತು UDR ಅಪರಿಚಿತ ಮೋಟಾರ್ ವಾಹನ ಅಪಘಾತ ಪ್ರಕರಣದಲ್ಲಿ ಅನಾಮಧೇಯ ಚಹರೆ ವೇಲಿಕೆ ಆಗಿರುವುದಿಲ್ಲ ಒಂದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. Day to day, my lord, we done the my lord investigation. Then, my lord, you will also kindly see that is dated 26/8/2024. One, my lord, that is ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಪಹರಣಕ್ಕೊಳಗಾದ ಬಾಲಕಿ ಭೀಮವ್ವ ಮತ್ತು ಆರೋಪಿ ಅಜಯ್ ಕುಮಾರ್ ಈತನ ಪತ್ತೆ ಕುರಿತು ತನಿಖಾಧಿಕಾರಿಗಳಾದ ನರಸಮ್ಮಯವರು ತಮ್ಮ ಜೊತೆಗೆ ರಾಜಪ್ಪ ಅಸೋನ್ಸೋರವರು ಕರೆದುಕೊಂಡು ಆದೋನಿಗೆ ಹೋಗಿ ಸಂಶಯಾಸ್ಪದ ವ್ಯಕ್ತಿಯಾದ ನವೀನ್ ರಾಜ ಈತನನ್ನು ವಿಚಾರಿಸಲಾಗಿ ಆತನಿಂದ ಯಾವುದೇ ಉಪಯುಕ್ತ ಮಾಹಿತಿ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ದಿನಾಂಕ 19/8/2024 ಸೋನ್ಸು ಬಾಲಿಕೆ ಮತ್ತು ಆರೋಪಿತರ ಪತ್ತೆ ಕುರಿತು ನೇಮಕ ಮಾಡಿ ಕಳಿಸಿದ್ದು, ಸದರಿ ಸಿಬ್ಬಂದಿಯವರು ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆಗೆ ಹೋಗಿ ಅಲ್ಲಿನ ಪೊಲೀಸ್ ಬಾತ್ಮೀದ ಭೇಟಿ ಭೀಮವ್ವ ಮತ್ತು ಆರೋಪಿ ಅಜಯ್ ಕುಮಾರ್ ಅವರ ಬಗ್ಗೆ ವಿಚಾರಿಸಲು ಯಾವುದೇ ಮಾಹಿತಿ ಸಿಗದೇ ಇದ್ದುದರಿಂದ ನಂತರ ಚಾಮರಾಜನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ವಿಚಾರಿಸಿ ವರದಿ ಪಡೆದುಕೊಂಡು ದಿನಾಂಕ 22/8/24 ಚಾಮನಗರ ಪೂರ್ವ ಮಹಿಳಾ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ವಿಚಾರಿಸಲಾಗಿ so many, even my lord, they went to the Mysore also.
ಈ ನಿಮ್ಮ ಸಿಡಿ ಪ್ರಕಾರ 24/3/2024 ಸಿಡಿ ಪ್ರಕಾರ
Please, ma'am.
ಪೇಜ್ ನಂಬರ್ 51 ಇಂಕ್ ಪೇಜ್
24.
ಪ್ರಕರಣದ ತನಿಖೆಯನ್ನು ಮುಂದುವರಿಸಿ 24/3/2024 ಪ್ರಕರಣದ ಉಳಿದ ಆರೋಪಿತರಾದ ಕುಬೇರ 20 ವರ್ಷ ರವರನ್ನ ಠಾಣೆಗೆ ಬರಮಾಡಿಕೊಂಡು ಬಾಲಕಿ ಭೀಮವ್ವ ಮತ್ತು ಅಜಯ್ ಕುಮಾರ್ ಅವರಿಗೆ ಮಾಹಿತಿ ಪಡೆಯಲಾಗಿದೆ, ಯಾವುದೇ ಮಾಹಿತಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು
ಅಕ್ಯೂಡ್ ಬಂದಾರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ.
ಹೌದೌದು, ಇವ್ರು ಅಕ್ಯೂಸ್ ಅಂತಂದ್ರೆ ಇವ್ರು ಮಾತ್ರ ಸ್ವಾಮಿ, ಪೇರೆಂಟ್ಸ್ ಮಾತ್ರ, ಪೇರೆಂಟ್ಸ್ ಮಾತ್ರ.
ಪೇಜ್ ನಂಬರ್ 51 ಸಿಡಿ. ಆರೋಪಿತರಾದ ಕುಬೇರ, ಅಕ್ಯೂಡ್ ಕುಬೇರ
ಇಲ್ಲ, ಆಕ್ಚುಲಿ ಅದು ಅಜಯ್ ಕುಮಾರ್ ಅಕ್ಯೂಸ್.
His father,
ಕುಬೇರ ಅನ್ನೋದು
accused father.
ವಯ 20.
ತಪ್ಪಾಗಿ ಫಾದರ್ ಸ್ವಾಮಿ, ಫಾದರ್ನ ತರಿಸಿದ್ವಿ,
ಅಜಯ್
ಫಾದರ್ನ
ಕುಮಾರ್
ಕರ್ಸಿದ್ವಿ.
ಫಾದರ್ ಇಸ್ ಆಲ್ಸೋ ಅಕ್ಯೂಡ್,
ಹೌದೌದು, ಅಕ್ಯೂಸ್.
ಮದರ್ ಇಸ್ ಆಲ್ಸೋ ಅಕ್ಯೂಡ್.
ಹೌದೌದು ಸ್ವಾಮಿ.
ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಅರೆಸ್ಟೆಡ್?
ಬಟ್ ನಾಟ್ ಅರೆಸ್ಟೆಡ್ ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ.
41A ನೋಟಿಸ್ ಕೊಟ್ರಿ, ಕಾಗ್ನಿಜಬಲ್ ಅಫೆನ್ಸ್ ಇತ್ತು,
ಹೌದೌದು
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರ ಇಂಟ್ರಾಗೇಷನ್ ಕರ್ಸಿದ್ರಿ,
ಹೌದು.
ಇಂಟ್ರಾಗೇಷನ್ ಕರ್ಸಿ ಅವ್ರ ಮಾಹಿತಿ ಪಡೆದು ಕೈ ಬಿಟ್ರಿ.
ಅಲ್ಲ ಮಾಹಿತಿ ಅಂತ ಅವ್ರು ಅಲ್ಲಿ ಇದಾರೆ ಸ್ವಾಮಿ, ದಿವಸ ಕರೆಸ್ತಾ ಇದೀವಿ ನಾವು.
ಅಲ್ಲ ಕರ್ಸೋದಲ್ಲ,
ಈ ಪ್ರೊವಿಷನ್ ಈಗ
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ವಾಟ್ ಇಸ್ ದಿ ನೆಕ್ಸ್ಟ್ ಸ್ಟೆಪ್?
that is my lord, we are calling them and we are tracing the mobile number.
ನೋಟಿಸ್ 41
ಅದೇ 41 ದಲ್ಲಿ
ಈ ಹೊಸ ಪ್ರಕಾರ 35.
ಅಲ್ಲ 35(3) ಪ್ರಕಾರ ನಾವು
once arrest notice is issued,
what
what is the next
ಅಲ್ಲ
step?
ವಿಚಾರಣೆ ನೋಟಿಸ್ ಅಂತ ನಾವು
The
ಕರೆಸ್ತೀವಿ.
persons are found, they themselves come to the police station, then
Yes.
what is the next step?
That's why not we are made an inquiry my lord to them, then they said that
Purpose of issuing arrest warrant.
ಅಲ್ಲ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಫಸ್ಟ್ ಗೆ
41 year ನೀವು ನೋಡ್ರಿ, please see the notice.
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅದು, ವೈ ಶುಡ್ ನಾಟ್ ಅರೆಸ್ಟ್ ಅಂತ ಅಲ್ಲಿ ಕೊಡೋದು.
ಅದು ಹೌದು ಸ್ವಾಮಿ.
41A is not a witness notice.
ಅಲ್ಲ ಅನುಮಾನ ಬಂದ್ರೆ
ನೋಟಿಸ್ ಆದ್ರೆ ನೀವು ಹೇಳೋದು ಸರಿ, ಕರ್ಕೊಂಡ್ ಬಿಡ್ಬೋದು ವಿಚಾರಣೆ ಮಾಡಿ.
ಹೌದು.
ಅಕ್ಯೂಡಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ವಾಟ್ ಸ್ಟೆಪ್ಸ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್?
ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಬಿಫೋರ್ ಲಾರ್ಡ್ಸ್ ಪರ್ಮಿಟ್ ಹಿಮ್ ಟು my lord make this. ಬನ್ನಿ ಮುಂದೆ ಬನ್ನಿ.
ವಿಚಾರಣೆಗಾಗಿ ನಾವು ಠಾಣೆಗೆ ಕಳಿಸ್ಕೊಡ್ತೀವಿ.
41A ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲೆ ಅವರು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಬಂದ ಮೇಲೆ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ?
ವಿಚಾರಣೆಗಾಗಿ ಕರೆದು ಈಗ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ 41A and 161(3). 161 ಕೆಳಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟದು ವಿಚಾರಣೆ ಕರ್ಸೋದು ವಿಟ್ನೆಸ್ ನ. ಇಲ್ಲಿ ಅಕ್ಯೂಡ್ ಕರ್ಸಿರೋದು ನೀವು. ಅಕ್ಯೂಡ್ ಕರ್ಸಿ ವಿಚಾರಣೆ ಮಾಡಿ ಕೈ ಬಿಟ್ವಿ ಅಂದ್ರೆ ವೆದರ್ ಯು ಫೈಲ್ಡ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಈಸ್ ಇನ್ ಪ್ರೋಗ್ರೆಸ್, ಯು ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್. ಈಗಲೂ ಇದ್ದಾರೆ ಸರ್, ಅರೆಸ್ಟ್ ಮಾಡಿ ಅದಲ್ರಿ. Till this day you have not come to the conclusion that no offense is committed. Investigation is in progress. Why you have not arrested this accused? Where is the report as to the interrogation of these accused? What interrogation you have made after arrest, after issuing arrest notice?
ಇಲ್ಲ ಅವ್ರಿಗೆ
ನೋಡಿ,
ಏನ್ ಸಸ್ಪೆಕ್ಟ್ ಏನ್ ಮಾಡಿದ್ರಿ
ಆ
ಅದನ್ನ
ಹುಡುಗಿ ಮೈನರ್ ಇನ್ನು. ನಾವು ಅದಕ್ಕೆ ನಾವು ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಕೂಡ ಬರ್ದಿದೀವಿ. ನೀವ್ ಇದನ್ನ ಬಹಳ ಸುಲಭವಾಗಿ ತಗೋತಾ ಇದ್ದೀರಾ. ಮೈನರ್ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ನೀವು ಏನ್ ಮಾಡ್ಬೇಕು ಆಗೋದನ್ನ ಮಾಡ್ತಾ ಇಲ್ಲ. ಮೇಜರ್ ಆಗಿದ್ರೆ ವಿ ವುಡ್ ಆಲ್ಸೋ ಸೆಡ್ ಆಲ್ ರೈಟ್, ಯು ಡು ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್. ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ ದಟ್ ಶಿ ಇಸ್ ಎ ಮೈನರ್. ಏನ್ ಮಾಡ್ತೀರಾ?
ಮೊಬೈಲ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಟೆಕ್ನಾಲಜಿ ಪ್ರಾಬ್ಲಮ್, ಮೊಬೈಲ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅಲ್ರಿ 41A ಕೆಳಗಡೆ ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಅರೆಸ್ಟ್ ವಾರಂಟ್ಗೆ, ಇಫ್ ಯು ಡೋಂಟ್ ಅರೆಸ್ಟ್ ದೆನ್ ವಾಟ್ ವಿಲ್ ಹ್ಯಾಪನ್ ದೆನ್? ಶಿ ಇಸ್ ಎ ಮೈನರ್ ಗರ್ಲ್. ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ನೀವ್ ಹಿಂಗ್ ಮಾಡ್ತಾರದ್ ನೋಡಿ ಅವ್ರಿಗೆ ಧೈರ್ಯ ಬಂದಿದೆ ಈಗ.
ಅವ್ರು ಕರ್ಕೊಂಬಂದ್ ಕುಂದಿಸ್ತಾ ಇದ್ದೀವಿ ಸರ್,
ಆ?
ಅವ್ರು ಸ್ಟೇಷನ್ ಕರ್ಕೊಂಬಂದ್ ಕೂಡಿಸ್ತಾ ಇದ್ದೀವಿ ಸರ್.
That is not the procedure. ಕರ್ಕೊಂಡ್ ಕುಂಡ್ರಿಸೋದು, it is illegal.
ಅಲ್ಲ ಅದ್ರ ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಅವ್ರ
ಪ್ರಯತ್ನ
ಕಡ್ಲಿಂದ
ಅಲ್ರಿ ಅದು.
ಅವ್ರ ಕಡ್ಲಿಂದ ವಿಲ್ ಗೆಟ್ ದಿ
It's a
ಇನ್ಫಾರ್ಮೇಶನ್.
cognizable offense.
ಹಳೇದು ಕೊಡಿ, CRPC ಹೊಸದು.
ಅಲ್ಲ ಈಗ ನಾವು ಅರೆಸ್ಟ್ ಮಾಡಿ ಅವ್ರನ್ನ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ. ಈಗ ನಾವು ಅವ್ರನ್ನ ಕಡ್ಲಿಂದ
ಮೊಬೈಲ್
ಅವ್ರ ಫೋನ್ಗೆ ನನ್ನ ಮಾಡಿದ್ರೆ ನಾವು ಟ್ರೇಸ್ ಔಟ್ ಮಾಡ್ಬೋದು ಅಂತ ನಮ್ ಪ್ರಯತ್ನ ಅಷ್ಟೇ.
ಯಾವ್ದು ಹೊಸ ಪ್ರಾವಿಷನ್ ಯಾವ್ದು?
BSN,
ಬಿ ಆಗುತ್ತೆ. 41B, 35B. ಇದು ಇನ್ ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದಿ ಆಫೀಸರ್ ಆಯ್ತು 35A. ಸೊ ರೀಸನಬಲ್ ಕಂಪ್ಲೇಂಟ್ 35B ಬರುತ್ತೆ. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರೆ ಅದೇ 35B ಕೆಳಗಡೆ.
seven years below.
35B ಕೆಳಗಡೆ ನೀವು ಇದು ಹಳೆ ಫಾರ್ಮ್ಯಾಟ್ಗಳನ್ನ ಇನ್ನೂ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ. ಹಳೆ ಫಾರ್ಮ್ಯಾಟ್ ಇದು ಯಾವ್ದು? ಇದು ಜುಲೈ 37, 2024 ಹೊಸದೇ. ಅದು ಹಳೆ ಅದೇ. So BNSS 35B ಕೆಳಗಡೆ, once the police officer is permitted to arrest them.
7 year below 7 years ಇದ್ರೆ ಅದಕ್ಕೆ below 7 years.
ಇದು ಎಷ್ಟಿದೆ? ಕಿಡ್ನಾಪ್ ಆಫ್ ಮೈನರ್
360.
Cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years.
Section 96.
Yes.
Immediately can arrest. Less than is the notice is required. Notice is mistake. Above 7 is notice mistake.
Kidnapping ಎಷ್ಟಿದೆ?
86.
Yeah, that is FIR, my lord, we produced FIR. Page number 12.
Ten years. Punishable with imprisonment which may extend to 10 years.
So notice also is not necessary.
We'll take action now. Further action, my lord, will take it, my lord. Even now also, my lord, we are searching that girl, my lord. If it trace, my lord, we'll produce that one. That is the assurance we made, my lord. As per that one, second status report is filed. Even now also, my lord, you will also grant, my lord, another 10 days time, my lord. If we found, my lord, we'll produce it before proponing this case, before lordship, my lord. And we'll proceed with those who has made the allegation against them also, my lord.
ಇದು ಬರೀ ಹಿಡಿಯಸ್ ಕಾರ್ಪಸ್ ಒಂದೇ ಅಲ್ಲ.
ಹೌದಾ proceedings say that
You have to proceed against the accused for the cognizable offense which is punishable with imprisonment for 10 years. 10 years imprisonment ಇದ್ರು ನೋಟಿಸ್ ಕೊಟ್ರಿ, ಠಾಣಿ ಕರ್ಸಿದ್ರಿ, ಇಂಟ್ರಾಗೇಷನ್ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇಲ್ಲ, ಸುಮ್ನೆ ಕೈ ಬಿಟ್ರಿ, ಅವ್ರು ಕರೆದ್ರಿ, ಏನ್ ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಬರದ್ರಿ 2 ಲೈನ್. This is the investigation.
we'll do it, my lord.
ಅವ್ರು ಕರೆಸಲಾಗಿ ಮಾಹಿತಿ ಇಲ್ಲ, ಲಭ್ಯ ಇಲ್ಲದ್ರಿಂದ ಅವ್ರನ್ನ ಬಿಡಲಾಯ್ತು.
ಸರ್ ಅವ್ರ ಮೊಬೈಲ್ ಟ್ರ್ಯಾಕ್ ಮಾಡಬೇಕು.
ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ದಿ ಮೆಟೀರಿಯಲ್ಸ್?
ಪೀಡಿಯರ್ ಆಕ್ಷನ್ ಇದೆ. ಅವ್ರ ಮದರ್
ಇಲ್ಲಿ ಮೆಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ.
ತಂದೆ ತಾಯಿನೂ ಅಕ್ಯೂಸ್ಡ್ ಪರ್ಸನ್ಸ್ ಅಲ್ವೇನ್ರಿ? ಕಂಪ್ಲೇಂಟ್ ಅವ್ರ ಮೇಲೂ ಇದೆ ಅಲಿಗೇಷನ್.
ಸರ್ ಅವ್ರದ್ದು
ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಮಾಡಿದೀರಾ ನೀವು?
ಕಾಲ್ ಬರ್ತಾವ ಅಂತ ಹೇಳಿ ಅವ್ರ ಸಿಡಿಆರ್ ಆಕ್ಷನ್ ಇದೆ ಸರ್, ಎಲ್ಲ ಮೊಬೈಲ್ ನಂಬರ್.
ಅದು ಆ ಹುಡುಗಂದ ಆಯ್ತ್ರಿ?
ಹುಡುಗಿ ಫ್ರೆಂಡ್ಸ್ ಆಕ್ಷನ್.
ಈ ತಂದೆ ತಾಯಿನ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ನೀವು ಅಂತ?
ಸರ್ ಮೊಬೈಲ್ ಕರೆಗಳು
ನೀವು ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ಡ್ ಪರ್ಸನ್ಸ್ ಅಂತ ಮಾಡಿದ್ಮೇಲೆ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ, ಅವ್ರು ಠಾಣೆಗೆ ಬಂದ್ಮೇಲೆ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ? ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಮೊಬೈಲ್ದಲ್ಲಿ ಅವ್ರು ಏನಾರ ಬರ್ಬೋದು ಅಂತ ತಿಳ್ಕೊಂಡ್ಗೇಸಿ ವಿ ಆರ್ ವೇಟಿಂಗ್ my lord.
Women can be retained in police station.
ಇಂಟ್ರಾಗೇಷನ್ ಯಾವ ರೀತಿ ಮಾಡ್ಬೇಕಂತ ಯಾವ ಕೋರ್ಟ್ ಹೇಳಲ್ಲ. ಇಟ್ ಇಸ್ ದಿ ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ ಆಫ್ ದಿ ಐಒ. ಅವ್ರಿಗೆ ಅವ್ರ ಸ್ಕಿಲ್ ಉಪಯೋಗಿಸಿ ಹೇಳ್ಬೇಕು ಅದನ್ನ.
We'll do it.
That is investigation.
But we'll do it, my lord, that your lordship not have it.
ಅದನ್ನ ನಾವು ಹಿಂಗ್ ಮಾಡ್ಬೇಕು ಹಂಗ್ ಮಾಡೋಕ್ ಹೇಳ ಅಗತ್ಯ ಇಲ್ರಿ. It is the duty of the IO.
We are making the effort, my lord.
IO powers ಕೊಟ್ರೆ ಅದಕ್ಕೆ.
This is second time. They have to be careful, my lord, when first time they went, my lord. And I also produced that B report also, my lord. Last, she only given the voluntary statement before the magistrate. Second time, see, at least they have to care against that.
ಜನಗಳಿಗೆ ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗೋದಿಲ್ಲ. She is a minor.
Yes, my lord.
She doesn't understand the consequences. But this boy should have been more careful.
That is also, my lord. That is also.
He should understand the consequences, and you people should tell the parents consequences ಏನಾಗುತ್ತೆ ಅಂತ.
ಇದು ಆಕ್ಚುಲಿ ಪೋಕ್ಸೋ ಬರುತ್ತೆ.
ಅದಕ್ಕೆ when it is clear that the girl is minor.
ಹೌದು ಅಲ್ಲ ನಾವು ಅದಕ್ಕೇನೆ ಮೈನರ್ ಇದ್ದದಕ್ಕೇನೆ ಡೇ ಟು ಡೇ ಮಾಡಿ we are interrogating.
ಅಲ್ಲ, even you are not registered the case under the POCSO Act.
Yes,
Victim is below 16 years.
POCSO Act. Definitely, my lord, that is. Another 10 days, my lord, you will also grant, my lord. We'll proceed with the, my lord. Then, my lord, we'll trace that girl also. First, our aim is, my lord, to get that girl, that's all. Thereafter, my lord, definitely we'll take action against.
ಅದಕ್ಕೆ ಏನು ಮೆಥಡ್ ಯೂಸ್ ಮಾಡಬೇಕು ಅದನ್ನ ಅವ್ರು ಚೆನ್ನಾಗಿ ಗೊತ್ತಿರುತ್ತೆ ಅವ್ರಿಗೆ.
ಅದೇ.
That is what my learned brother is saying.
Please.
ಏನು ಹೊಸದಲ್ಲ ಅವರಿಗೆ. But it appears that they have taken it casually.
Last time ನಾವೇ ಮಾಡಿ ಕರ್ಕೊಂಡು ಬಂದಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಹೌದು.
ನಾವೇ ಮಾಡಿದ್ದು.
ಅದೇ.
ಈ ಸಲ ಕೇರ್ಫುಲ್ ಆಗಿಬಿಟ್ಟಿದೆ. ದಟ್ ಇಸ್ ಅ ಪ್ರಾಬ್ಲಮ್. ಸಿಮ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಫೇಸ್ಬುಕ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Oh, you should know what are the other tactics that are to be used.
That's why not we are asking also that girl's friend also ಎಲ್ಲಾದ್ರೂ ಅವರೇ ಏನಾದ್ರು ಮಾಡ್ತಾರ ನಾವು. We are waiting for that one. That's all, my lord. We'll file the, my lord, further report, my lord, with
ಬರ್ಕೊಳ್ಳಿ. The learned government advocate who had filed status report on 22nd of October 2024. Has filed one more status report along with the memo today. Full stop. We have perused the status report. And we are constrained to express our dissatisfaction of the manner in which the respondent police have proceeded with the matter after registering the FIR. Stop. It need not be overemphasized that the victim girl is a minor. Full stop. Therefore, appropriate action should have been taken by the respondent police, having regard to the fact that in the complaint, not only the young boy is named as the accused person, but his parents too are named as accused persons. Full stop. Therefore, it was not sufficient to have issued notice to the parents of the accused person. Full stop. Appropriate action in accordance with law should have been taken, which we find lacking in the investigation. Full stop. Next para. At this juncture, learned government advocate submits that appropriate action will be taken and it will be ensured that the presence of the victim will be brought before this court. Stop. Next para. Release this matter.
Lord, you also direct the parents of that victim, my lord, to cooperate with the, my lord.
ಏನ್ ಕೋಆಪರೇಟ್
ಅಲ್ಲ ಫೋನ್ ಏನಾದ್ರು ಬಂದ್ರೆ ಅದೆಲ್ಲ ಸ್ವಲ್ಪ
ಅವ್ರು
ಹೇಳ್ತಾ
ಹೇಳ್ತಾ
ಇದ್ದಾರೆ.
ಇರ್ತಾರೇನ್ರಿ ಅವ್ರ ಫೋನ್ ಬಂದ್ರೆ
ಅವ್ರು ಯಾಕಂದ್ರೆ ಇದ್ರ ನಮಗೂ ಸ್ವಲ್ಪ ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದಾಗ.
ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಬಿ ಸರ್?
ಅಲ್ಲ ಅವ್ರಿಗೆ ಬೇರೆ
They
ಯಾರಿಗೆ
are saying the girl is not found and if they get a
ಸ್ವಲ್ಪ-
call, will they not come and tell them?
ಅವ್ರ ರಿಲೇಟಿವ್ಸ್ ಯಾರು ಇಂತಲ್ಲಿ
ಅಲ್ಲ,
ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಕು ಸ್ವಾಮಿ.
ಹಂಗಲ್ಲ.
ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ವಿಲ್
IO has got right to issue notice them also.
ಅವ್ರು
They are
cooperate
required, he
ಮಾಡಿದ್ರೆ
can summon them to the police station.
ಅವ್ರ ಮೇಲೆ ಡೌಟ್ ಇದ್ರೆ ಮಾಡ್ರಿ.
ನೀವು ಅವ್ರನ್ನ ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ ಈಸ್ ದೇರ್ ಎನಿ ಬಾರ್?
no, no,
ಇವಾಗ ಎಲ್ಲ ಪವರ್ಸ್ ಹೋಯ್ತ್ರಿ, ಇದ್ರ ಮಾತ್ರ ಯೂಸ್ ಮಾಡ್ತಿಲ್ಲ.
will do it.
506 ಅಫೆನ್ಸ್ ಇದ್ರು ಬೇಲಬಲ್ ಆದ್ರೂ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ಹೌದೌದು.
ಇದು
This
ನಾನ್
is a-
ಬೇಲಬಲ್ ಆದ್ರೂ ಅರೆಸ್ಟ್ ಮಾಡ್ತಿಲ್ಲ. ಅದು
Will-
ಯಾಕೆ? ಫಾರ್ ದಿ ರೀಸನ್ಸ್ ಬೆಸ್ಟ್ ನೋನ್ ಟು
will do.
He knows the region. He knows the region more.
ಅಲ್ಲಲ್ಲ.
ಅಲ್ಲ ದೇರ್ ಸಿ ಅವ್ರಿಗೆ ಮನ್ಸಲ್ಲಿ ಕೂತ್ಬಿಟ್ಟಿದೆ, ಈ ಹುಡುಗಿ ಇಷ್ಟಪಟ್ಟು ಹೋಗಿದ್ದಾಳೆ, ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ.
ಇಷ್ಟಪಟ್ಟು ಹೋದ್ರು ಬಿಡಬಾರ್ದು.
ಪ್ರಾಬ್ಲಮ್ ಈಸ್ ಶಿ ಇಸ್ ಅ ಮೈನರ್. ದಟ್ ಇಸ್ ವೈ ವಿ ಆರ್ ಸೇಯಿಂಗ್, ವಿ ಆರ್ ಎಂಫಸೈಸಿಂಗ್ ದಿಸ್.
Yes.
ಅದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅವರು. We can't permit her to do this. Release this matter on 6th of November 2024.
I request you lords about 11th, my lord.
Huh?
11th,
411.
No,
Huh?
no,
1 week, man.
please come on 6th, we'll see.
Great.
6th, my lord.
Yes,
6th. 6th,
6th of November.
please.
CL number 11, Sudarshanam.
In this matter, my lord, your lordship directed me to file the, my lord, undertaking affidavit. Regarding, my lord, there is a proceedings by the deputy commissioner regarding payment of the, my lord, amount, my lord, which work done by the complainant. In a similar matter, my lord, we already filed the undertaking affidavit. What of? As per Annexure R1, my lord, page number 5, my lord. This total amount is, my lord, arrived at 9,87,446. This, he done the, my lord, some computerized work, my lord, that scanning and all, service rendered by the complainant, my lord.
To
The, my lord, all the districts, the 5 taluk, my lord, Indi, Sindhigi, Vijaypur, Muddebala, and for that one, my lord, this amount is assessed at the rate of 4% interest in the proceedings. He only agreed for this amount, my lord. This 9,87,446 is arrived. Conclusion that one. In that, my lord, 6 lakh rupees is already paid. Another 4 lakhs rupees, my lord, we have to pay that one, around 4 lakhs rupees. That will be undertaken by the, my lord, assistant commissioner before lordship, my lord. That will be payable within 2 months from the date of the order. That is, my lord, 9/11/2024. That will be expire on 9/11/2024. That will be paid.
affidavit
This is,
ಈ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ರಾ?
ಇದ್ರನ್ನೇ affidavit.
You are filing it.
Yes, ma'am.
You are filing it.
Undertaking affidavit for payment of the.
Consequent to this type of an undertaking,
Yes, ma'am.
what were the orders passed?
That is, I produce Annexure R1, my lord.
Annexure R1. Order.
Order passed by the
Order of
deputy
this court.
commissioner. Yes, lord. These the judgments.
Where is the order of this court?
Order. Similar matter.
Consequent to this, you said in similar matters, similar type of undertaking you are
Yes,
given.
ma'am, that is the order. ma'am.
Consequent to that, what orders were passed?
That is the.
Yes,
Please, ma'am.
you can proceed.
Please,
Same orders can be passed.
please, please. Obliged.
Literally, it is submitted that the undertaking made in the memo will be reduced into affidavit.
Please.
Your affidavit is already filed.
This is the affidavit.
Your affidavit is already filed.
Yes, yes.
So therefore, this sentence is not necessary.
Yes. Memo is not necessary, my lord.
Ade.
Undertaking update, but today I am filing before lordship.
Already memo along with the affidavit you have filed.
Yes, ma'am.
Alva.
Yes.
So
Memo memo along with the order was produced before lordship in that case, my lord. So recording that one, my
Correct.
lord, that was disposed of.
here you have filed an affidavit.
Now affidavit, this is the affidavit undertaking. Yes, undertaking.
Undertaking to pay
Pay
this,
that
and
amount.
they have also agreed to
Yes,
receive the same.
yes, yes.
So therefore, small changes have to be done to this order.
Yes, that's all.
Alva.
So that's.
ಅಲ್ಲಿ memo along with affidavit of the assistant commissioner, Vijayapura district. Alla subdivision.
Indeed.
Indi subdivision. Vijayapura district has been placed on record, and it reads as follows on the
Para 5 of the affidavit, my lord. Today's affidavit, my lord. Of last line, my lord. Hence, I am undertaking to pay this.
4 and 5. 4 6 lakhs is paid.
That is paid.
ಅದು ಬರ್ಬೇಕಲ್ಲ.
ಹೌದು, ಹೌದು.
ಹಾ?
ಹೌದು.
4 and 5, paragraphs number 4 and 5 of the affidavit. Extract ಮಾಡ್ತೀನಿ. ಆಮೇಲೆ in view of the above, proceedings are dropped. We stop. Needless to state that if the interest as quantified is not paid within the time of 2 months as undertaken in the affidavit, the petitioner is at liberty to seek for revival of the proceedings. Full stop. ಯಾರು ಬಂದಿದ್ದಾರೆ?
Assistant Commissioner, who has filed the update, my lord, before
The
lordship.
presence of the Assistant Commissioner, the Abid, is taken note of. Yes.
Please. Great.
Much obliged.
Drop bantala.
Seal number 12, Hitesh Padial.
Lordship, intra-court appeal is not maintainable. The other day I submitted. The government took adjournment.
Yes.
Yes, Additional Advocate General is on the line, my lord.
My lord, my lordship permission, my lord.
Yes.
My lordship has passed an order, your lordship passed an order in Dharwad at the same issue. My lordship has held that yes, intra-court is not maintainable. We have no case on that concern. My lord, however, my lordship has granted the liberty. If the Supreme Court is given the liberty or it's a reverse or set aside the order, then liberty for the review as a granted. In this case also same, my lord. So, my lord, this now once it's an appeal is not maintainable, then remains to with regard to the contempt, we need to be pay amount or we have to be undergo the proceedings of the contempt proceedings.
Yes.
My lord, in this case, my lord, we also requested, the brought to the notice of the authority of the secretary to withdrawal of this appeal. Jivo is going to be passed an order. On that basis, we are going
There
to
is
be.
no need to for you to withdraw it. We will dismiss it as not maintainable.
Yeah.
What
My
is the
lord,
next action that you are required to take? You please tell
Yes.
about that.
My lord, within a week, we are going to be pay amount or we are going to be alternatively undergo the proceedings. The off the record, my lord, the week's time may be granted for the contempt concern. This lordship may be taken decisions on that. My lord, the Supreme Court also is pending in this case that observations also in the SLP number in the Supreme Court, my lord, is pending. In SLP number, my lord, this my colleague is submitting. SLP number 12658 of 2020-22.
ಯಾವ ವಿಚಾರ?
Intra-court is a management case which we filed an appeal in the pending in the Supreme Court. With that observation, my lordship has a liberty, Dharwad, my lordship has lordship and Justice Rai has passed an order in writ appeal number 230 of 2020-23. Based on that, lordship may be taken. And we have no other options. We have to undergo this order of the lordship.
Alala, the said order has been confirmed at the answer the honorable apex court ಅಂತಿದೆ.
Yes, it's a pending.
2024.
There is a two. There is a two Supreme Court judgment.
It has been upheld ಅಂತ ಬಂದಿದೆ.
Upheld ಆಗಿದೆ.
There is a two Supreme Court judgment, one in the case of city municipal.
Supreme Court ಅಲ್ಲಿ file ಮಾಡಿರೋ SLP has been dismissed now.
That's what my humble submission to your lordship, There is a Supreme Court two judgment, One is that is dismissed. I agreed, I am saying that management of Bharat, the fridge winter, that is pending in the because this main cases only lordship has taken decisions in the Bharat case management case only. So that is pending. That liberty. There is a two Supreme Court judgment, One is dismissed illegal. We have no options on that. So that the illegal is depending on the Bharat case. Bharat case is a pending. Management of Bharat, wherein our limited company is a pending in SLP number.
If that is the case, why it was not mentioned before the Apex Court? How is it that the orders are confirmed while
My
dismissing the SLP?
My lordship is aware that we are sitting here and the government advocate has to be oversight, not to be mentioned. That I agreed. My lordship observation is absolutely right. We also felt it like that, but which I can't express.
Now we
Absolutely.
we can only give you a week's time. Otherwise, we'll proceed.
And that will be better, my lord. So that by the time we will see that week's time may be granted, my lord. 6th, my lordship has given the date. Some other case I will also come. 5th, lordship has given now. 5th, one case has given, my lord, Karnataka Neeravari case. We are physically coming there, and that day we will conclude the matter.
The respondents are aged more than 55 years. Since 87, they have been struggling.
Having regard to the orders passed by this court on 21/10/2024, noticing the fact that an SLP filed at the hands of the respondent state in SLP bracket civil close diary number 32290 of 2023 was dismissed by order dated 15/3/2024, confirming the orders passed by coordinate bench of this court in writ appeal number 100230 of 2023. Learned Additional Advocate General which would seek for a short accommodation to seek instructions and make submissions. Last time we have recorded the same thing.
And we have spoken with the secretary, my lord, of the record I am saying, my lord. So we have said that we have no.
Released this matter on 5th of November.
Much obliged, my lord. Great.
Yes.
Bill number 13, Raja Venkatappa Nayak.
My lords, I appear for respondent 2, my lords. My lord, we seek for a week's time, my lords, to file our compliance affidavit. In this, in the writ petition order, my lords, there was a direction to consider the
counsel for respondent number 2 submits that if a week's time is granted, compliance affidavit will be filed. Stop. Next para. Accordingly, release this matter on 6th of November.
Seal number 14.
My lord, I will take notice for respondent number 3 and 4, my lord.
Learned government advocate takes notice for response number
3 and 4.
3 and 4 also,
Lordship, my lord,
along with respond number 5.
please.
Ah.
Lordship, grant, my lord, 2 weeks time, my lord. There is a direction to the, my lord, do the POD, my lord, and issue the FAR number 10. For that, now, my lord, the government order is issued, my lord, regarding only online application has to be submitted. For that is the reason, my lord, we are pursuing that one online. That requires some time, my lord. 2 weeks time, any date may be fixed, my lord. After 2 weeks, we'll proceed with the work, my lord, and
online application
I think that process is already sent, my lord. That's why, my lord, we are wait, my lord, online, my lord, the turn has to be called.
Learned government advocate seeks for 2 weeks time.
Please.
For compliance. We'll stop. Next para. Accordingly, release this matter on 11th of November.
Please.
Seal number 15, Satish Kumar D.
Complain the order of single bench.
I appear for the respondent but 2 and 3 minutes.
Yes.
Minutes, in my humble opinion, as in view of the endorsement issued at NHSC page number 17 minutes, the contempt petition would not survive minutes. They may challenge the endorsement minutes. Page number 17 NHSC.
but not.
ಅವರೇ ಹಾಕಿದಾರಲ್ಲ ನಮ್ಮ ಇದನ್ನ.
ಅವರೇ ಹಾಕಿದ್ದಾರೆ. Endorsement is
Annexes
already
has
issued.
been filed by them.
Yes, by
My
them.
lord.
Then
They have, instead of challenging the endorsement, they have pursuing this contempt petition. That would not be maintainable, my lords. In view of the endorsement saying that it cannot be considered in one of the reasons. Compliance with the judgment of the Honorable High Court of Karnataka, Kalaburagi bench, WP number so and so. And by considering the prima facie evidence available within the university, it is decided that the documents submitted by you were not found in order, and hence your request has been considered, has not been considered. So it is for them to challenge the endorsement, my lord, if they are aggrieved before the proper forum. It would not amount to contempt, my lords.
unauthorized deduction of salary,
Yes, my lord.
deduction made from the salary.
Yes, my lord.
Ah,
Actually, my lord, in the single bench order already comply the order. Furnish the entire documents, bills and everything. So he submitted already the entire bills and voucher also. Thereafter issue the endorsement, my lord, only consider only for, you will not file the G17 and third in a order issue ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. Otherwise no.
Therefore, my lord,
Single bench order ಆದಾಗ ಎಲ್ಲ submit ಮಾಡಿದಾನೆ already one. You not proper submit ಅಂತ ಹೇಳಿ ಮತ್ತೆ endorsement ಕೊಡ್ತಾರೆ ಅವರು.
that endorsement needs to be challenged, my lords. It is not that we have not replied, we have not considered. In that case, my lords, I would have considered that it would amount to contempt. So contempt petition wouldn't lie, my lords, against the endorsement. They may have to challenge the endorsement if they are aggrieved.
please see the order. The order is respondent university is directed to consider the bills produced
Yes.
along with the writ petition. And
Yes.
if it is found in order, shall pay the amount recovered under the said bills to
Yes.
petitioner in a maximum period of 2 months.
Please, my lords. Therefore, in reply to, then they have given the representation as per Annexure 16.
Yes.
With reference to subject cited above, I request you to kindly stop the deduction from the salary to pay the deducted. So and so, so and so. In reply to the same, my lords, at Annexure C,
Yes.
we have considered their representation and answered that because they are not in order, we have given out the reasons also, that you were appointed in the university as MTS in the year 2016, later you were promoted as LTC in the 2019, and also promoted as UDC in the so and so. When you were working as MTS, we were asked to look into the electrical maintenance in the university. At the time, the university gave a check of rupees 82,000 every month in favor of you to pay the salary of temporary employees working in the electrical section. That as per GFR 17, every employee who takes advance in the form of money or a check for any purpose has to settle the account by producing bills, vouchers within 15 days of the receipt of money. That you have not settled the account from October 2018 to March 19. In this regard, a notice was issued on 20th May 21 for non-settlement of advance amount. For the above notice, you replied on 3rd June 2021, stating that you have settled the advance in the same academic year. As per your statement, the office of the FO once again verified the document and found that you have not settled the advance. The same was communicated to you through email on 11 June 2021, stating that if the advances were not settled by January 2022, the same shall be recovered from the salary. And later, a personal notice through email dated 21 December 21 has been issued to the settled account. Non-settlement of advance for the employees was objected by the auditor in his report. By following the natural justice principle, you were given sufficient time. Though as per norms, you had to settle it within 15 days from the date of receipt of amount. No other deduction from your salary has been started from 1 January to 2022. After 1 year, 9 months, you have simply submitted a representation dated 19 September 2023 to the finance officer by attaching some papers which are looking like photocopies of paid receipts vouchers and which were never submitted to the university. You have also filed a writ petition before the Honorable High Court of Karnataka, Kalaburagi, seeking a direction to the university to stop the deduction from your salary by attaching some documents. By considering the plea of the advocate, the Honorable High Court has passed the order. The respondent is directed to consider the bills produced along with the writ petition, and if it is found in order, shall pay the amount covered under the said bills to the petitioner in a maximum period of 2 months from today. By considering the prima facie evidences available with the university, it is decided the documents submitted by you were not found in order, and hence your request has been considered. Therefore, my lord, if they are agreed by this representation, they can definitely go.
This is
Last paragraph.
ಇದು ಪ್ರಿವಿಯಸ್ ಆರ್ಡರ್ my lord. ಮೊದಲ ಆರ್ಡರ್ ಆಗಿತ್ತು. ಆಫ್ಟರ್ ಹಿಟ್ ಆದ್ಮೇಲೆ ನಾನು ವಿತಿನ್ 2 months ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿ ಅದು ಬಟ್ ಬಿಫೋರ್ ಆರ್ಡರ್ ಈಗ ಹೇಳ್ತಾರೆ ಅವರು. ಹಿಟ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ಅವರೇ ಹೇಳ್ಯಾರ ಸಬ್ಮಿಟ್ ಮಾಡು ಅಂತ ಹೇಳಿ. ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ.
Considering the plea of the advocate, the so and so directed to consider the bills produced along with the writ petition.
Yes.
Yes.
In the order, it is noticed. Therefore, the amount covered in bills of outsourced employees are deducted from salary of the petitioner. Petitioner therefore has now sought for mandamus to the respondents seeking for payment of his salary. Learned counsel for the respondent submitted that necessary receipts are not given despite repeated demands by the petitioner, and therefore the university has settled the account of the petitioner. Learned counsel for the petitioner submits that now he has furnished the copies of the receipts and bills for having taken the work from outsourced employees, and therefore the petition needs to be allowed. It is directed to consider the bills produced along with the writ petition.
Submit model.
Adakke avaru, they have said, yes, we have seen it.
Yes.
It does not look like any receipt.
Photocopies.
By considering the prima facie evidence available to the university, is decided that the documents submitted by you are not found in order, and hence your request has been reconsidered.
So, as per,
Nothing can be done.
no, as per order, I submit the along with the bills.
Yes,
They have
that is
considered,
true.
said, no, we are not satisfied.
Sorry, ಇದೇ order ನಾನು ಮತ್ತೆ read challenge ಮಾಡೋದನ್ನ ಮತ್ತೆ not considered ಮತ್ತೆ ಇದೇ order.
ಹೌದು, ನೀವು ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರ ಅದೇ ಮಾಡೋದು. ಬರ್ಕೊಳ್ಳಿ. Learned counsel of the respondent university and the vice chancellor of the university submits while pointing out to Annexure C that the complainant has in fact furnished copy of the endorsement issued by the university on 24/6/2024, subsequent to the orders passed by the learned single judge. Full stop. In the said endorsement dated 24/6/2024, the respondent university has clearly stated that having considered the documents submitted by the petitioner along with the writ petition, the university is not satisfied with the documents, and therefore it is held that the documents are not in order. Full stop. Accordingly, the request made by the petitioner for reconsideration has been made and rejected. Full stop. Learned counsel would therefore submit that even according to the complainant, it is clear that there is compliance of the directions issued by the learned single judge. Full stop. Next para. For contra, learned counsel for the petitioner complainant submits that the respondents are simply declining to consider the documents subsequently produced by the petitioner along with the writ petition. Full stop. Next para. On hearing the learned counsels and on perusing the petition papers, more particularly the endorsement dated 24/6/2024 at Annexure C, we are satisfied that the respondents have reconsidered the documents submitted by the petitioner along with the writ petition and have issued the endorsement dated 24/6/2024. Stop. If the petitioner is, however, not satisfied with the said endorsement, it is open for the petitioner to raise a challenge to the same in accordance with law. Full stop. Next para. The content petition is accordingly dropped.
Great for me.
16, this is Alalli.
Take notice for R2, my lord, and comply the order of the learned single judge, my lord.
Learned government advocate takes
ಇಲ್ಲ ಅಲ್ಲ ಒಂದು ವೀಕ್ ನಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿ
ಅಲ್ಲ,
ಇದು ಬೇರೆ
filing the
respond number 2.
26.
As per the direction of the my lord, Lawrence single judge, my lord, to restore the name of the complainant in the RTC, my lord. Or after issuing the notice to the work board and to the complainant, my lord, we restored.
ಅದು ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಮಾಡಿದ್ವಲ್ಲ
The same.
ಸೇಮ್ ಯಾವ್ದದು ಕಂಟೆಂಪ್ಟ್ ಪಿಟಿಷನ್
ಅದು ಬೇರೆ ಈ ಕೊಟ್ಟಿದ್ದು 183
So far as my lord, Anakshar
ಅಲ್ಲ
R4, my lord.
ಅದರಲ್ಲಿ ಅವರು ಒಂದು ವೀಕ್ ನಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಫ್ರಮ್ ಪ್ಯಾರಾ 7 ಮೇ ಕೈಂಡ್ ವಿಸ್
ಆಯ್ತು ಡಿಲೇ
ಮಾಡುತ್ತಾನೆ ದಟ್ ಮೇ ಬಿಟ್ ಇನ್ ಟೇಕನ್ ನೋಟ್ ಆಫ್ they have undertaken that they will do it in week.
Everything, but there is 4 survey numbers, my lord. 3 survey numbers, my lord, already mutation and RTC is also affected. So far as my lord, 1 survey number, that is my lord 627 bar star bar 7, page number 10, my lord, kindly see.
11
Page number 10. This is mutation order is already affected. That is dated 25/10/2024. Deleting the name of the my lord Waqf board. In view of the my lord that server condition, my lord, in the that is my lord page number 11, my lord, column number 11, Karnataka Waqf board anta ಕಾಣಿಸ್ತಾ ಇದೆ. So that has to be deleted. Within 1 week it will go, my lord. That's why I had undertaken that one also in the affidavit. Para number 7, my lord. It is only regarding 1 survey number.
ಕಾಲಮ್ ನಂಬರ್ 11 ಅಲ್ಲಿ ಇರೋದು ಹೋಗ್ಬೇಕು
ಅದು ಹೋಗ್ಬೇಕು. Rectify servers down ಆಗಿದ್ರಿಂದ that is not affecting, my lord. It will be delete, my lord. That is undertaken in the para number 7. That is already done. Once mutation order is passed, my lord, automatically that has to go.
learned government advocate has filed an affidavit of the Tahsildar grade 1, Afzalpur Taluka, along with documents, more particularly the RTCs and mutation extracts. Stop. Next para. In paragraphs number 4, 5, and 6 of the affidavit, it is stated that the RTCs have been rectified, and in respect of the 3 survey numbers, namely
627 bar 7 627 bar 7
bar star bar 1
plus 7
27 bar star bar 2 and 627 bar star bar 3, the name of the complainant have been restored in column number 9. Full stop. However, in paragraph number 7, in respect of survey number 627 bar star bar 7, it is stated that although mutation orders have been passed on 25/10/2024, and the name of the petitioner is reflected in column number 9, however, in column number 11, the name of the Waqf board continues, and the same will be deleted in a couple of days now. Stop. Next para. although there is a delay on the part of the revenue officers in complying with the directions issued by the learned single judge. Nevertheless, we are satisfied that the orders have been complied. Stop. Next para. Accordingly, the contempt petition stands closed. Full stop. Needless to observe that if the undertaking given by the Tahsildar in paragraph number 7 in respect of survey number 627 bar 7 is not complied, the complainant is permitted to revive the contempt petition.
Please.
Serial number 17, Geeta Annarao Sajjan Shakti.
List this matter of the service of notice on respond. Yaar nodre respond number.
Respond number 1.
Data.
The second respondent state, my lord, others, my lord, Medical Council at Rajiv Gandhi University, National Medical Commission.
Government advocate direct madilva.
R2, my lord, I'll take.
Huh?
R2, my
Learned
lord,
government advocate takes notice for
R2.
point number 2. List this matter after service of notice on respond number 1. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned government advocate.
Please.
Serial number 8, SS Alalni, 18.
In this matter, my lord, also complied the direction of the learned single judge. My lord. Yes. Happy for you.
Same RTC na?
Same,
Same.
same,
Huh?
same. No worries. In this matter, my lord, that name is deleted, but there is no pending.
Column number 11 ಅಂತ ಬರೀತಾರಲ್ರಿ ಎಲ್ಲ ಈ affidavit ಗಳಲ್ಲಿ.
ಅದರ 11
Column
ಅಂತಂದ್ರೆ
number 9.
ಅಲ್ಲ 11 ದಲ್ಲಿ
ಇಲ್ಲ, 11
ಅವನ
ನಲ್ಲಿ
ಹಕ್ಕುಗಳು ಅಂತ ಬರ್ತದೆ sir.
9 ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಸರ್.
11 ದಲ್ಲಿ
They have
delete ಆಗುತ್ತೆ.
inserted the name of the work board in column number 11 only, not 9.
Name of the khatedar is shown in
Is the
column
one-
number
yes,
9.
9,
So
correct.
therefore,
Yes.
what they should have said is,
Yes.
the name of the petitioner has been restored in column number 9 and the name of the work board in column number 11 has been removed.
Delete.
ಹಂಗೆ ಹೇಳ್ಬೇಕಾಗಿ.
ಹೌದು ಕರೆಕ್ಟ್.
ಅಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 11 ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಹಾಕೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ.
Correct.
ಅದು
Encumbrance
ಋಣಗಳು
is-
ಏನಾದ್ರು ಎನ್ಕಂಬರೆನ್ಸ್ ಇದ್ರೆ ಮಾತ್ರ ಕಾಲಮ್ ನಂಬರ್ 11 ಬರೋದು.
Any income.
Otherwise, your name will not be reflected in column number 11.
Correct.
This statement is wrong. That your name has been restored in column number 11 ಅನ್ನೋ ತಪ್ಪು.
ಇಲ್ಲ
9 ದಲ್ಲಿ
ಇಲ್ಲ ಅಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ನಮ್ಮ ಹೆಸರು.
The name of the work board has been removed from column number 11. ಇಷ್ಟು ಬರ್ಬೇಕಾಗಿತ್ತು.
ಅಷ್ಟೇ ಕರೆಕ್ಟ್.
Absolutely correct. That was done, my lord. That in the mutation order and RTC, that is done.
Same ಈಗ ಹೇಳಿದ್ನಲ್ಲ, ಸೇಮ್ ಆರ್ಡರ್. ಆದ್ರೆ ಇದು ಬರಲ್ಲ ಅಷ್ಟೇ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7 ಏನ್ ಬರೋದು? ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 7 ಬಗ್ಗೆ ಅಲ್ಲಿ ಹೇಳಿದೀವಲ್ಲ ದಟ್ ದೋ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ ಮ್ಯೂಟೇಶನ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ರಿಮೂವ್ಡ್ ಅಂದ್ಬಿಟ್ಟು ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರೋದಿಲ್ಲ ಇದ್ರಲ್ಲಿ. There is complaints. The name of the work code has been removed from column number 11.
Yes.
Huh?
Great.
Yes. ಯಾವ ತಹಸೀಲ್ದಾರ್ ಅದು?
ಅಫ್ಜಲ್ಪುರ್.
ನಾಲ್ಕು ಸರ್ವೆ.
ಸೇಮ್ ಅಫ್ಜಲ್ಪುರ್.
ಸೇಮ್ ಇಂಡಿ.
ಇಲ್ಲ ಅಫ್ಜಲ್ಪುರ್.
ಅಫ್ಜಲ್ಪುರ್.
Yes.
Number 19, Vinayak Apte.
R1 my lord, pro forma party my lord. That writ appeal filed by the housing board. That is serial number
37.
37.
For filing, filing we are intimate to the issue endorsement to the appellate. Before filing appeal, we are issue endorsement to the respondent matter.
Mike is ready.
Respondent.
Complaints ಆಗಿದೆಯನ್ರಿ?
ಇಲ್ಲ.
ಮತ್ತೆ?
No complaints.
No complaints, but we are preferring appeal matter.
You have preferred an appeal?
Yes.
And other day, your lordship heard that matter, my lord, regarding housing board. That cancellation of their auction
Yes,
proceedings.
auction.
Two times. my lord,
ನೀವು ಹಾಕಿರೋದು.
ಅವ್ರು ಹಾಕಿದ್ರು.
ಅದೇ appeal. That is 37.
Council for the respondent, Karnataka Housing Board submits that the board has filed
Yes, sir.
an intra-court appeal in WA number
Number ಏನು?
ಇದು post ಆಗಿತ್ತು ಮುಂದೆ.
37 man.
Serial number 37.
37.
Yes.
ಇದೆ ಅದು. ಜೊತೆಗೆ ಕೇಳ್ಬೇಕು.
Two 2000165 of 2024. Which is also listed in serial number 37 in the cause list today. Yes. ಅದ್ರಲ್ಲಿ ಹೇಳಿ 37 ಅಲ್ಲಿ.
Yes.
ಹೇಳಿ. ಏನಾಯ್ತು ಅದ್ರಲ್ಲಿ? Your past orders? Order sheet ಕೊಡಿ ಅದು. ಮತ್ತಾಗೆ
Yes, my lord. That the appellant filed the above appeal against the order of single judge in WP number
Yes.
20.
ಬಿಡಿ ಆ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಬಿಡಿ ವಿ ನೋ.
Yes. On 36/2024 my lord. And against the respondent appellant framed in respect of house the shop, commercial shop bearing number 3, that shop number 20,889. And that is and rate has been fixed by the housing board 1,200 man. And he has the
legal grounds ಏನ್ ಹೇಳ್ರಿ ಸಾಕು.
Yes.
We know the facts.
Yes, that housing board is allotted on the ground that one applicant.
There was some complaint received.
Yes, madam.
There was complaints received from some
One
quarters.
Madam, the appellant received one complaint from one Danaya element on 3/7/2018.
And therefore, what is your legal ground now? What is wrong in the order passed by the learned single judge?
And he has stating that he has filed application before the respondent.
What are the legal grounds, sir? Any judgment that you want to cite?
And that he has assigned to communicate, to inform the respondent, appellant, to rate of the housing board is very low. And the appellant, respondent number 3 to 4 are colluded. And one has been a respondent, one Sayyad, who has bid, these also colluded. Hence, he has not a proper bid action man. And on the ground that the same and the party, appellant have responded, 322, they are one and same family. One and same, and that is a public property matter. On the basis of public property, has filed complaint before the respond on the ground that we are cancel this site. And and further,
Facts, Bidi sir, you please tell us, sir, have you come with any judgment?
yes,
This is the third time that the matter is being
yes,
listed.
yes, I will. One judgment matter. Divya Jyoti Vidya Kendra. And in this case, one,
last time.
in this case, a writ petition, there one complaint filed before they responded on the ground that the cancellation of the state site matter. Commercial, C site has been cancelled.
ಇದನ್ನ ನೋಡಿದ್ವಲ್ರಿ ನಾವು ಲಾಸ್ಟ್ ಟೈಮು.
And Rule 10, Rule 12, Rule 12, Class 10 of the Karnataka Housing Board Rules and Regulation Act, matter. The board shall have the right to cancel the allotment and take position of the site house if at any time it is forced at the allottee has made any misrepresentation or false statement in the application for the allotment. And it is a public property, each and every person to protect their property. And if official has any committed by the officer, that will be duty of the every citizen to protect.
You have returned the money?
Yes, so where refunded that money?
You are refunded.
Yes, refunded.
You have received the money?
No, sir.
Huh?
No, sir.
Yes, sir. I will produce that.
They remitted the amount to our account, but we did not withdraw.
Huh?
They remitted the amount to our account, some partial amount. But our clients, you see, did not withdraw the money.
He has not issued that amount, my lord.
But money has come to your account.
Yes, yes.
Not entire money, sir.
ಎಷ್ಟು ಬಂದಿದೆ?
I would take instructions for not entire amount.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ information?
Yes.
And after passing up the order, Madam Lord, that amount is also now again transferred.
Huh?
Whatever amount they see remitted, after passing up the order, my lord, under consideration, the means complainants have also paid the entire money now.
The complainant?
Have already remitted the amounts after passing up the order.
Huh?
After passing the impugn order by the
Ah.
learned single judge,
Ah.
the petitioners, that is the auction purchasers, have also remitted the amount,
Again?
transferred again.
Huh?
Yes.
At the time passing order, he has refunded the amount. He has not issued that amount, my lord.
ಬರ್ಕೊಳ್ಳಿ. ರೀ ನೀವು ಸ್ವಲ್ಪ ಕಷ್ಟ ಪಡ್ಬೇಕ್ರಿ, ಹಿಂಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ. ಮೂರ್ ಸರಿ ನಾವು ಕಳಿಸ್ತೀವಿ ನಿಮ್ನ. ಏನ್ರಿ ಒಂದ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡ್ ಬರಕ್ ಆಗಲ್ಲ ನಿಮ್ ಕೈಲಿ ಅಂದ್ರೆ? What kind of a work are you doing?
I mean, one submission, Rule 10 class, Housing Board Act.
Defending a board is not so easy. Little bit of effort you should do.
That is a.
ಮೂರನೇ ಸರಿ ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇರೋದು ಕೋರ್ಟ್ ಮುಂದೆ.
We are refunding that amount and the Housing Board is the rule as per.
Please understand, sir, we have said, we have asked you, what are the legal grounds on which you are challenging the order of the learned single judge?
On the ground that.
What is the legal ground?
We are found that there is a misrepresentation.
Therefore, in that regard, can you not get a judgment of the Supreme Court?
Yes, I got it. Two thousand 22. Karnataka Law General 2022 Part 3 KLJ 193 Supreme Court.
Yes.
That is in BBMC.
ಯಾವ paragraph?
2022 KLJ man.
ಯಾವ paragraph ರೀ?
Para number 2, 3A and 4, 5 man.
ಓದಿ. Which is the relevant paragraph?
4 by law. Now, para 3, the notification
Para?
date, para 3.
Ah.
The notification date 15/10/1988 has referred to the site proposal, 3 different locations, layout plan. Further, clause 16 of the notification stated this. Thus, section 16, the BDA issue the rights to allot the site in any layout other than the one of the preferred by the applicant owning the unconcerned for litigation the implement. If any, the BDA also reserve the right to the allot site in any one of the future layout that is in the layout not advanced the present. Para 4. Para 4. The authority was again to enable to allot the.
ಆಯ್ತು. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 37 ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ. Learned government advocate takes notice for respondent number 1. Learned counsel Shri
Vinayak
Apte, who appeared for response number 2 to 5, the original writ petitioners before the learned single judge. He is present in the court and takes notice for respondents number 2 to 5. Stop. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as learned counsel for Response number 2 to 5. We'll stop. Next para. The learned single judge is of the opinion that the very fact that the sale was put up for public auction by e-procurement, ruled out any foul play. Full stop. However, it is the contention of the appellant KHP that immediately after the process of public auction, it received a complaint that in the said site number 3, 44 sites could be formed and the price accepted, namely rupees 1,350 per square feet, was too low, and therefore it generated suspicion about the validity of the auction. Full stop. We find that in this regard, various judgments of the Honorable Supreme Court including Subodh Kumar Singh Rathore versus Chief Executive Officer and others, reported in 2024 SCC Online SC 1682. The Honorable Apex Court has held, after considering various judgments, various earlier judgments, that what is discernible is that the Apex Court has consistently underscored that any decision to terminate a contract must be grounded in a real and palpable public interest, duly supported by cogent materials and circumstances, in order to ensure that state actions are fair, transparent and accountable. Full stop. Public interest cannot be used as a pretext to arbitrarily terminate contracts, and there must be a clear and demonstrable ramification or detriment on the public interest to justify any such action. Full stop. This court is therefore of a prima facie opinion that the matter requires consideration. Full stop. Consequently, there shall be an interim stay of the impugned order passed by the learned single judge in WP number 202162, 2018. Yes, you please go through these judgments.
Please, sir.
Huh? ನೀವು ಅಷ್ಟೇ ರೀ, please come prepared. If this is sufficient reason. ಕೇಳಿಸ್ಕೊಂಡ್ರಲ್ಲ? You please download this judgment. There are various judgments cited there. Please go through all of them and make it sufficient. Yes.
Number 9.
CCC ಕೆಳಗಡೆ 200-190 of 2024 shall be called along with this matter. Yes.
CL number 20. N. Shivayogimuth.
My lords, I have served the copy of the hand summons to respond number 5, my lords. I have served the hand summons to respond number 5.
And summons.
Yes, my lords, but I will file along with the memo, my lords.
You have not filed.
Not it.
Learned counsel for the appellant submits that the hand summons taken out to respond number 5 has been served. Stop, however, the hand summons will be filed in the office.
Please.
Navaga,
Today, sir. Now,
during the course of the day.
please,
Yes.
my lords, since some urgency.
List,
Lordship, on 4th, maybe my lords.
Lordship, one humble submission.
ಅದು ಯಾವ್ದೋ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್
That 21, next matter it is.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ?
21.
21.
ಹೌದು.
ಅದರಲ್ಲಿ we have said not to precipitate.
Please.
Lordship, in this matter.
One is filed by the builder.
Why you have not taken steps?
The step has been taken on 26th October 2024 itself.
Allah, but you have not furnished copies of the appeal memo.
I submitted to the respondent number 2.
That is the office objection that is raised.
Saturday itself is I served.
Yes, my lord.
The-
Copies are served.
Interim directions given in writ appeal number 200250 of 2024 shall hold good in this matter also. Takondo, serial number 21 nalli, learned counsel for the appellant submits that the needful has been done. Puts the office to verify and issue notice.
My lord, one,
Interim directions given on 21/10/2024 shall continue till the next date appear.
Fourth, matter may be posted on 4th.
one more.
ಇದರಲ್ಲಿ 20 list this matter along with writ appeal number 200250 of 2024 ಅಂತ ಹಾಕೊಳ್ಳಿ. List both these matters on fourth ಆಗಲ್ಲ.
Senior counsel is going to engage this matter.
Fourth ಆಗೋದಿಲ್ಲ, Monday ಆಗೋದಿಲ್ಲ. Other than Monday,
My
you
lord,
can
I-
ask for any,
My lord, I am the respondent
other
number
than
5.
Monday,
my
you
lord.
can ask for any other date.
Your Lordship, I will ask for the senior, any date. I mean, I
Take
will
the
say to
instruction.
the court.
We'll take
officer,
the
Lordship.
instruction from the.
I ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ, the same date will be given.
Lordship, in this case, issue has to be, notice has to
My
be issued.
lord, I am the respondent number 5 in serial number 20, my lord.
ಯಾವುದು?
20, serial number 20.
ಹಾ
21 has to be connected with this, Lordship. Same,
20.1
yes, Lordship. 21.
that is filed by whom? 20.1
Nandakishore Bhoo.
Nankishore Bob.
you are appearing for.
Nankishore.
The appeal is filed by whom?
Mail, respondent.
What is that? Filed
Owner,
for?
Your Lordship, owner.
Like
My lord, I am the
case in,
respondent number 5 in
Shivaji
serial
Bhatt.
number 20, my lord.
one of the purchasers of the apartment.
Yes, sir.
One of the purchasers of the
We-
apartment.
My lords, in 20, we are the purchaser of these individual flats, my lords.
What about
The-
you ಅಂತ ಕೇಳಿ?
you
Owner of the land.
land, yes, ma'am.
Owner of the land.
My lord, I am the respondent number 5 in the serial number 20, my lord.
Yes, yes.
My lord, I need 4 weeks time to get this C certificate from the register, my lord. Party in person. I need to
ಏನು?
appear before the party in person committee, my lord.
Ah,
I need 4 weeks time.
Serial number 20.
ಅವರೇ ಮಿಸ್ಟರ್
Sharan
ಶರಣ್
Desai.
ದೇಸಾಯಿ.
Yes, my lord.
ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹೇಳಿದ್ವಲ್ಲ, ಅಲ್ಲಿ ಶ್ರೀ ಶರಣ್ ದೇಸಾಯಿ, ದಿ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್, has made submissions through video conference. Top. He seeks for some time to
4 weeks
enter
time, my lord.
appearance and secure the necessary certificate from the
Key
committee
certificate, my lord.
to appear as party in person.
Yes.
Yes.
Permission to appear as a party in person, my lord.
Writ appeal 20.1 ನಲ್ಲಿ ಕಮಿಷನರ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
I am DP Ambekar. I am.
DP Ambekar.
Learned counsel Sri DP Ambekar takes notice for respondent number 1. Learned government advocate takes notice for respondent number 2. ನೀವು ಬಿಲ್ಡರ್ ಮಿಸ್ಟರ್ ಮೊಹಮ್ಮದ್ ಬೂಕ್, ನಂದಕಿಶೋರ್ ಬೂಕ್, you will have to enter appearance for respondent number 4 in the other matters. You are the owner of the land, isn't it? Learned counsel Sri Nandikishore Bhoop. He is requested to take notice for respondent number 4. ಅಲ್ಲ ಇದು ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ನೀವಾ? Learned counsel Sri Ravi B Patil. He is requested to take notice for respondent number 4. ಇದು ಬಂತಲ್ಲ ಮಿಸ್ಟರ್ ಶರಣ್ ದೇಸಾಯಿ, ಈಗ ಇದರಲ್ಲಿ 20.1 ನಲ್ಲಿ ಶ್ರೀ ಶರಣ್ ದೇಸಾಯಿ, ದಿ ಒರಿಜಿನಲ್ ರಿಟ್ petitioner and respondent number 3 herein has made submissions through video conference and seeks ಅದೇ same order ಅವ್ರಿಗೆ.
Connected matter copy to.
In 20.1 manner, petitioner counsel be directed sir copies. 20.1 ಅಲ್ಲಿ Nandakishore book.
Today, during the in all these writ appeals, the learned counsels for the appellants are directed to serve copies of the appeal memo along with annexures on the learned counsel Sri DP Ambekar, appearing for the Karnataka Housing Board.
Corporation, city corporation.
Kalaburagi Mahanagara Palike.
Kalaburagi.
And the learned government advocate. Please. And the original writ petitioner, party in person. ಅವ್ರಿಗೆ copies ಎಲ್ಲ all these matters you have to serve a copy.
We have served my lords. Along with the petition, I have served.
Not already served.
Please.
4 weeks are granted to the petitioner, writ petitioner, party in person, to secure necessary certificate to appear in these matters as party in person.
Much obliged, my lord.
Any particular date? Any particular date?
ಏನ್ interim directions ಕೊಟ್ಟಿದ್ದೀನಿ, why are you worried now?
Not the specific date.
Yes.
Serial number 22, hearing none aye. Liaquat Farid Ustad.
Appearing for appellant. Suit for partition in subject question, the above matter.
Paper book is filed.
Paper book is filed.
Yes. The matter was
counsel for the appellant submits that paper books have been filed in the office. Will stop office to verify.
ಆಮೇಲೆ ರಿಕಾಲ್ ಮಾಡು. ರಿಕಾಲ್ DNP ಆಗಿತ್ತು on the
1617 days.
Lord, that is by wrongly mentioned, my lord, by 860 days. By
file ಮಾಡಬೇಕು. There is a delay. ಇಲ್ಲಿ as per office calculation PD 886.
ಕಾಸ್ಟ್ ಮಿಲ್ಲರ್
ಕಡಿಮೆ ಇದೆ ಆಕ್ಚುಲಿ, ನೀವು ಜಾಸ್ತಿ ತೋರಿಸಿದಿರಾ ಅಂತ.
ಹೌದು 886 ನಾವು ಕೋವಿಡ್ ಕಡಿಮೆ
886 how do you explain? We do not know.
ಕೋವಿಡ್ ನಲ್ಲಿ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಕಾಸ್ಟ್ ಮಿಲ್ ಅಲೋ ಮಾಡಿ.
Learned counsel for respondent number 12711 has been designated senior counsel. ಮತ್ತೆ
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಲ್ಲ.
ಯಾರ್ದ್ರಿ ವಕಾಲತ್ತು? ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ ಅಥವಾ ಇವ್ರು ಇರ್ಬೇಕು, ವಿಕಾಸ್ ಯಾದವ್. Vikas Kumar. Respondent. ಬೇರೆ ಯಾರ್ದು ಹೆಸರಿಲ್ವ ಅಲ್ಲಿ? ಒಬ್ಬರದೇ ಇದೆಯಾ? ಅವ್ರ ಆಫೀಸರ್ ಯಾರು ಅದು? ಗಣೇಶ್
Kalburgi.
Ganesh Subhash Chandra Kalburgi.
Yes.
Office is directed to show the name of learned counsel Sri Ganesh
Subhash Chandra
Kalburgi.
Yes.
For response number 1 to 7 and 11.
Yes.
Full stop. Release these matters on 5th of November. Or Burley, then we'll consider.
I will serve the copy on.
Serve ಮಾಡಿ.
ಅದೇ ಅದರಲ್ಲಿ directed to be take notice ಅಂತ ಮಾಡಿದ್ರೆ.
ಆಮೇಲೆ ರೀ, let him come and appear. We'll ask him. If he's not interested, we can't force them.
Yes.
Yes.
CL number 23, Harshavardhan or Mali Patil.
These are matters regarding Lord lake rejuvenation, Lord amount which was Lord levied by the government authorities, Lord one matter, some matters Lord pending before,
Corporation.
by the Lord development authority.
Development authority.
Urban development authorities, Lord, they are Lord levying a fixed charge for Lord lake rejuvenation.
Yes.
This issue, Lord, is pending, Lord, for consideration before the principal bench. There are certain writ appeals, Lord, filed.
Writ appeals,
Yes, ma'am. In the writ appeals, they are pending. The issue was this, Lord. We challenged the constitutional validity of, Lord, the amended provision which levied, Lord, a fixed charge, Lord, on all the properties, irrespective of the.
2015.
ಹೌದು, ಅಲ್ಲಿ 2014 ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಸಮ್. Lordships, Lord, are willing to hear, Lord, will proceed with the matter. Because earlier occasion, Lord, the court had said that, Lord, since matters are pending, to be awaited.
I don't think these matters are pending before the principal bench.
Lord,
Because
yes,
one learned single judge
yes,
had heard matters,
yes,
mainly on ground rent, a rent
constitutional
fee prescribed,
yes,
for sanctioning a plan.
Yes.
A part of it was regarding the fees fixed for lake rejuvenation.
Lord, constitutional validity of section 18A, which was amended,
Correct.
Lord, and Lord, a
That
provision
is also
was
part
inserted.
of
Yes,
the
yes.
contention raised in that matter.
The constitutional validity was upheld.
Yes.
Thereafter, Lord, certain appeals are filed, Lord, writ appeal 169. Lord, I'm not on, Lord, that count. If Lordships are, Lord, willing to hear, Lord, I will go ahead, Lord, present the appeal. Because there was an order earlier, Lord, saying that, Lord, since principal bench matters are pending. we may have-
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ ಕೇಸಲ್ಲೇ ಇತ್ತು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ I just brought it to the notice of Lord, the day before the previous.
No, it can't arise out. It can't arise out of these matters coming from Kalaburagi bench.
Yes.
You are saying similar matters which were filed in the principal bench.
Yes.
Orders have been passed and now the appeal is pending before the
Appeal is
division
pending,
bench.
where, my lord, section 18A's validity is, my lord, in question, which is also challenged in the present case.
See,
And also,
I have dealt with these matters
Yes.
as a learned single judge for the second time after the orders were passed by His Lordship Justice Nagaprasanna.
Yes.
Quashing all the demands raised by the BBMP, including lake rejuvenation fee.
Yes. As
Adadmele, they brought in amendments
How?
to the KMC Act, BBMP Act,
how it was-
and the Karnataka Town and Country Planning Act.
Yes.
I have
Amendment-
heard these matters
Yes.
for more than 3 months.
Yes.
And I have reserved them for orders.
Lord, as single judge.
There I was told
They have
that
amended.
the challenge raised to section 18A
Yes.
has been upheld.
Yes.
I don't think any matter is pending before the principal bench. Please verify.
I'll verify that, my lord. my lord, the next question will be, my lord, let us assume that, my lord, 18A validity is
Has been
upheld.
upheld. If the,
Now
if the,
18A is,
if the validity has been upheld by the division bench,
Yes.
please first get the copy,
yes, yes.
then we'll consider.
Lord, the next ground that is available is I should get the benefit of that amendment. Lord, what happened is, my lord, during pendency of the writ petitions, considering, my lord, several writ petitions and, my lord, certain orders, the amendment was brought to 18A and, my lord, that fee of rupees 1 lakh was reduced proportionate to, my lord, the city and, my lord, the population in the city. So what was 1 lakh, my lord, for Gulbarga, it will be somewhere around 50 or 60,000. But we under protest, my lord, we have paid 1 lakh per acre. So that amended provision, will that apply and we are entitled for the balance amount? That will be, my lord, open for.
Want to seek benefit of that amended provision, you are free to do it. If you give a representation and they reimburse that amount, this appeal will become infructuous.
With that also, my lord, can be, if that is, my lord, limited and the validity is, my lord, it is.
At the request of the learned counsel for the appellant, relist this matter on 11th of November.
Wait, by that time.
Yes.
There are two numbers, my lord, which were quoted by the Development Authority last occasion. I've checked, my lord, they are pending. Writ appeal 1691 of 2014 and another connect.
Pending, yeah.
Pending pertaining to this issue. This was submitted by, my lord, the Development Authority Council. Tengli. I'll again, my lord, check.
Submissions were made. I heard that matter for nearly 3 months.
Yes, your lordships, my lord, in the capacity of single judge or my lord?
Single judge.
Yes, I'll verify that. my lord, whether
Subsequent to the amendment, amendments were brought in the year 2022.
How?
After Justice Nagaprasanna
quashing, my lord.
quashed the demand notices.
Yes.
Because there was no provision at all.
How?
For demanding this fee, there was no basic provision itself in the act, both the KMC Act and the BBMP Act. So therefore, now they have brought in the provision. Those provisions are again under challenge.
Yes.
That is what I have heard.
Yes.
But they made submissions that regarding lake rejuvenation, the same orders were passed by His Lordship Justice Nagaprasanna.
Yes.
Saying that the validity has been upheld. 18A validity has been heard and upheld, and that was the submission made before me.
How?
So please verify.
I'll do that.
Yes.
Seal number 24, Lur Satyanarayanachari.
Appear for respondents. For objection on IA, filed amendment application. Now we are seeking for referring the matter to mediation for settlement. Matter may kindly be referred to mediation.
Mediation. At the request of learned counsels on both the sides, the matter stands referred for mediation.
Yes.
Date may fix on 6th or 7th, my lord.
6th.
Date may 6th.
The parties are directed to appear before the mediation center on
6th.
6th of November. Beligena, Madhyana?
Madhyana.
At 2:30 PM.
Yes.
Yes.
Seal number 25,
I today will continue. Adan Karpur family court matter. Yes. Sorry.
seal number 60.
60.
Seal number 60, Papugoda Siddhapur.
Adalri family court matter idu serial number 8. Serial number 8.
Seal number 8, Ganesh Subhash Chandra Kalburgi.
Exponent is present. Yes. ಏನಾಯ್ತಪ್ಪ? ಏನಪ್ಪ? ಏನಂತೆ?
ಅವನು ಇದು ಲವ್ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಂಡಿದ್ದದ ಸ್ವಲ್ಪ ವಿಚಾರ ಬಹಳ ವಿಚಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಸ್ವಲ್ಪ ಮೈಂಡ್ ಏನೋ ಇದಾಗಿಲ್ಲ ಅಂತ.
ಏನೋ
ಮನಸ್ಸು ಬಹಳ ಇದಾಗಿದೆ ಅಂತ ಲವ್ ಮ್ಯಾರೇಜ್ ಆಗಿದ್ರಿಂದ ಬಿಡ್ಲಿಕ್ಕೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗ್ತದೆ, ಏನೋ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಂತ.
ಇನ್ನು ಟೈಮ್ ಬೇಕಾ?
ಸ್ವಲ್ಪ ವಿಚಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಟೈಮ್ ಬೇಕಂತ.
ಫೈಲ್ ಮುಂದೆ ಏನ
ಅದು ಆಯ್ತು, ಯಾಕೆ ಕೇಳ್ತಾರೆ ಸಾಹೇಬ್ರು?
ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ. ಇಲ್ಲಿದ್ರೆ ವಿ ವಿಲ್ ಪ್ರೊಸೀಡ್ ಟು ಹಿಯರ್ ದಿ ಮ್ಯಾಟರ್.
Yes, ma'am.
ಒಂದು ವಾರ ಟೈಮ್ ಅಷ್ಟೇ. ಇಲ್ಲಿದ್ರೆ ನಾವು ವಿಲ್ ಕನ್ಸಿಡರ್ ದಿ ಮ್ಯಾಟರ್ ಅಂಡ್ ಪಾಸ್ ಔಟ್. at the request of the respondent, release this matter on 6th of November. 6ನೇ ತಾರೀಕು ಬರ್ಬೇಕು.
But serial number 60 not 66 not sir.
ಏನು?
Last time, last date of hearing, the both the parties are present before this court not sir. The matter may be taken on the chamber not sir. Or mention to mention the matter on the 60 not. Both the parties are present, appellant and daughter and his husband not sir. ಬಂದಿದ್ದಾರೆ not sir. All the parties are present.
We'll see at 2:30. Please. ಕಳಿಸ್ರಿ.
ಊಟ ಇನ್ಮೇಲೆ Bill number 25, Kumar Kallu.
I am appeal for the respondent number 1 minute. I have filed the including application for the proposed respondent number during the pendency of the appeal, my lordship, the appellant number 2 has filed the joint development agreement between the, my lordship, the developers, page number 8 of the implementing application, my lordship. Already the interim order granted, my lordship, on during the pendency of the appeal, my lordship, they have sold out the property and plot.
What interim order?
Not to draw the final decree.
Not to draw the final decree proceeding.
During
Now
the
the question
pendency
is,
of the appeal, my lordship, the joint agreement development has been made and the plots has been allotted and to agree to sell the plots, my lordship. My lordship, the share of the appellant will be automatically going to the respond number 1. He is also entitled for the share. My lordship. Suit filed by the respond number 1.
Who has sold the sites?
sites,
appellant number 2. my lordship.
sites are not sold. Only
I'll
NA
produce a
permission
copy of
is
the-
obtained, a layout is made. And is subject to result of the this appeal. If they are entitled for share in the property, they will get share in this property also.
Page number 19, my lordship.
Saubhagya was the plaintiff.
Yes, my lordship. The present respondent, my lordship.
The suit for partition.
Partition, suit for partition. Suit
Yenaitu?
has been decreed, my lordship.
Decreed.
Yes, 3/20th share has been allotted, my lordship. The trial court has granted the 3/20th share has been granted, but all the suit schedule properties, page number
1/4.
Yes.
1/4.
Yes.
3/20th share.
Share, 3/20th share.
In suit item number so and so, 7 acres.
1/4 in some of the properties and 3 by.
And item number
Yes.
A of residential property. The plaintiff is also
3 by
having
20.
1/4 in the suit land 486 situated at Gangwar.
Kanwar
village.
village. Also, the item number Z, I, my lordship, he has made the agreement of joint agreement with the developers to make the plots 153 and to sold out the plots is now presented, sold out the plots, my lordship. Automatically, the share of the respond number 1 has go.
Sale ಯಾವ ಮಾಡಿಲ್ಲ. Only layout has been made. Layout has been made. They have produced certain documents that NA permission is obtained and layout is made. Properties are, plots are not sold. Now instead of.
July 2016, the judgment was passed.
Yes.
After that, you have proceeded to do all this.
Yes.
After that, during pendency of this case, they have made a layout, they have obtained NA permission in respect of one of the property. And the layout has been made. That will anywhere benefit to the plaintiff also. Suppose if she succeeds in this case, that will anywhere to the benefit of the plaintiff also.
You should understand that firstly, the
Yes.
judgment of the trial court has gone in favor of the plaintiff.
Yes.
Plaintiff.
Despite that,
Despite.
if you are trying to do this,
Lord, my submission to lordship is, instead of all these things, let the matter be heard itself for final hearing. Now the question is, there was the plaintiff herself admits, my lord, in the plaint, that there was a 9th year, 1990, there was a partition between her father and brothers. It was entered and it was reduced into writing. That is in the exhibit D1. Now the trial court goes to the extent of saying that it disbelieves when the plaintiff herself admitted in her, my lord, plaint that there was a partition between the members of the family, and one of the property which has been acquired by them belongs to the uncle of the plaintiff. My lord, the question is, how can the court disbelieve that partition date when she has admitted in the, my lord, plaint itself? And even in the chief examination, she herself admits. If that is so, as per the apex court judgment and this court judgment, then all the uncles should be made as a party to the proceedings. They can't, because they have got the share in the properties. And those properties have been included in the hotspot. That could not have been included in the hotspot, which was allotted to the uncles of the plaintiffs. This is the crux of the case. So partition suit itself will be not maintainable. So my submission to lordship is let the matter be admitted and posted
You have
for
filed the
hearing.
application for impleading.
Yes, Lord.
She
Implementing
wants
This
to,
proposed respondents.
joint development agreement has been made by the Lordship, the SR developers. They are making the plots to the one of the landed properties in the share granted by the
Notice has been issued.
not in notice has not issued.
Notice is not issued. Issue notice on IA number 1 of 2024.
Also, the maintain the status quo Lordship regarding the making the plots Lordship, alienating the plots Lordship.
Allapa, you can't make this kind of a submission without there being an application.
I filed the application also. Madam.
An application.
Vacating the interim order granted by this earlier.
Huh?
Vacating the interim order granted by the earlier Lordship, the 28/11.
What application have you filed?
Vacating the interim application, interim order granted by the earlier.
Not to draw the decree on the FTP.
IA number 2/24, Lord.
I'll advise the party my lord, not to precipitate the matter. Let the matter be heard.
Which is the interim order?
28/11/2016, Lord.
Drawing up of the final decree shall, meanwhile, drawing up of final decree shall remain stayed. ಅಷ್ಟೇ.
ಇವರು ಅಲೋ
ವೆಕೇಟ್ ಮಾಡೋದು ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
During the pendency of the appeal, these are changes in the they automatically share will be.
Therefore, you will have to file a separate application.
Yes.
What is the use of asking for vacating this order?
Lesser application.
This is the crux of the case, my lord.
No, Lord.
So the matter can be posted for
Not
hearing
admitted,
itself. ಯಾಕಂದ್ರೆ ಇರೋದೇ ಅಷ್ಟೇ when they admit in the plaint that already partition took place between the uncles of the plaintiff and her father, and memorandum would exhibit D1 is also marked. The court goes to the question.
You want to file an application?
Yes, Lord.
Please file. Please file. Yes.
Notice to the impleading application. Notice to the.
This order ಆಗಿದೆ. Yes.
Number 26, Babu H. Metagudda.
Payment appeal for enhancement and also challenging liability. Liability challenge. But in this case, my lord, their
ಅವರು ಹಾಕಿದಾರ?
ಇಲ್ಲ ಅವ್ರಿಲ್ಲ ಸ್ವಾಮಿ. ಇದು claimant appeal for enhancement and liability challenge. Liability only, my lord, is as per pleadings, my lord, traveling as a labor under first respondent, my lord. Lorry. But cross examination ಅವ್ರೇನ್ dispute ಮಾಡಿಲ್ಲ. But only tribunal come to conclusion, my lord, only owner, not para 12 of the judgment.
New India Assurance.
ಅವರು ಶಶಿಕಲಾ ಜಗೀರ್ದಾರ್ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ.
ಓನರ್ ಮೇಲೆ.
ಓನರ್ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ನೀವು ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದನ್ನ ರಿಕವರ್ ಮಾಡೋದೇ ದೊಡ್ಡ ಕಷ್ಟ.
ಇಲ್ಲ ಅದನ್ನೇ
ಅದ್ರ ಮೇಲೆ ಇನ್ನೂ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. ಲೈಬಿಲಿಟಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಎರಡು ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಯಾರು?
ನಾನು ಕ್ಲೇಮೆಂಟ್. ಲೈಬಿಲಿಟಿ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೆ ತಪ್ಪಿದೆ ಅಂತ ಹೇಳಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅದು
liability should have been fixed on the insurance company.
Owner of the vehicle comes before this court only.
Description ಅಲ್ಲಿ ಇಂಡಿಯಾ ಅನ್ನೋದು ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ. ನ್ಯೂ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ ಆಗೋಗಿದೆ ನೋಡಿ ಸ್ವಲ್ಪ.
ಕಾಸ್ಟ್ ಟೋಟಲ್ ನ್ಯೂ
ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಹೌದು ಟೈಪ್
ಕರೆಕ್ಟ್ ಕೊಡ್ರಿ.
ಹೌದು ಮೇಡಮ್ ಕರೆಕ್ಟ್ ಟೈಪ್ ಮಿಸ್ಟೇಕ್
ಕೊಡ್ರಿ. ಯಾರಿದ್ದಾರೆ? ಇಂಡಿಯಾ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ ಆಗಿದೆಯಾ?
ಶಶಿಕಲಾ ಜಗೀರ್ದಾರ್ R3 ಅಪೇರ್ ಆಗಿದ್ದಾರೆ ಸರ್.
ಶಶಿಕಲಾ ಜಾಗೀರ್ದಾರ್. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಆಮೇಲೆ
ಇದೇನ್ ವೆಹಿಕಲ್ ಇದು?
ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪೇರ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ ಅಷ್ಟೇ ಮಿಲಟ್.
ವೆಹಿಕಲ್ ಏನಿದು?
ಮಿಲಟ್
ಏನ್ ವೆಹಿಕಲ್ ಇದು?
ಲಾರಿ ಮಿಲಟ್.
Traveling along with the goods.
ಹೌದು ನೀವು ಇಂಡಿಯಾ ಅಂತ.
ಅಲ್ಲ ಇವ್ರು ಯಾರು?
Cleaner.
You claimed as a cleaner, is it?
ಕ್ಲೀನರು ಲೇಬರ್ ಅಂತ ತಗೊಂಡಿರ ಸ್ವಾಮಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಮಿಲಟ್. ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಲೇಬರ್ ಅಂತ ಇದೆ ಸರ್. ಬಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಾಗೂ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಅವ್ರದ್ದು. ಆಮೇಲೆ ಕಂಪನಿ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ಬಿಫೋರ್ ದ ಟ್ರಿಬ್ಯುನಲ್ ಮಿಲಟ್. Only court come to conclusion owner is a claimant have not examined owner of the vehicle. Para 12 of the judgment kindly see.
So if you are claiming as a cleaner, workman's compensation ಹೋಗಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲ ಎರಡೂದ್ರಾಗ ಮಾಡ್ಬೋದು. ಕ್ಲೇಮ್ ಎರಡೂದ್ರಲ್ಲಿ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ. ಅದೇನ್ ಇದಿಲ್ಲ ಸರ್. ಅದೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
ಆಪ್ಷನ್ ಇಸ್ ವಿತ್ ದಿ
ಆಪ್ಷನ್ ಕ್ಲೇಮೆಂಟ್ ಇದೆ ಆಪ್ಷನ್ 167 ಕೆಳಗೆ. ಅಲ್ಲಾದ್ರೂ ಹಾಕ್ಬೋದು ಇಲ್ಲಾದ್ರೂ ಹಾಕ್ಬೋದು.
Why is it coming up today? Notice is already issued.
Delay in 188 days filing this. Delay ಮೇಲೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಸರ್. ಅವ್ರು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಸರ್.
Matter is called out. There is no representation for respondent number 3. Release this matter on 6th of November.
ಅವ್ರ ಓನರ್ ಏನಾದ್ರು ಅಪೀಲ್ ಹಾಕ್ಯಾರ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಸರ್. ಆಯ್ತು ಹಾಕಲ್ಲ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡು ಹೋದ್ರೆ ಅವಾಗ ಬರ್ತಾರೆ.
ನಮಗ್ ರಿಕವರಿ ಆಗಲ್ಲ ಅಂತ ನಾವೇ ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
ಆಗಲ್ಲ.
ಓನರ್ ಕೇರ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. ಅದರಲ್ಲಿ ಮಹಾರಾಷ್ಟ್ರ ವೆಹಿಕಲ್ ಮಹಾರಾಷ್ಟ್ರ ಗಾಡಿ ಇದೆ ಸ್ವಾಮಿ.
ಕೆಳಗೆ ಕೈಲಾಸಿ.
Matter is called out. There is no representation for the appellant. ಏನ್ರಿ
27.
We had requested you.
That's why, my lords, I made an enquiries. They are ready to settle. For even at the initial stage itself, my lords, when after the death, and there were some criminal proceedings.
ಅದಲ್ರಿ
Bringing LRs on. Bringing LRs. Are bringing LRs, my lords? Your lordships have my instructions. My colleague has appeared on that day. With regard to the settlement, not now the court, even after bringing the LRs.
Who has passed away?
The husband.
ಈಗ ಹಸ್ಬೆಂಡ್ ಆದ್ಮೇಲೆ ಮುಗಿತಲ್ರಿ ಇದೆ?
ಇಲ್ಲ, ಅದೇ there is a one judgment, division bench judgment of this honorable court.
ಬಟ್ ಅವನೇ ಸತ್ತ.
ಇಲ್ಲ, bringing LRs on record ಅಂತ ಹೇಳಿ. To set aside the decree passed against me.
ಎರಡನೇ ಮದುವೆ ಆಗ್ಬೇಡ್ರಿ ಅಂತ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಿರೋದು ಇದು.
ಇಲ್ಲ, ಅದು ಅಲ್ಲ ಮೇಲೆ ಇದರಲ್ಲಿ ಡೈವರ್ಸ್ ಡಿಗ್ರಿ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
ಡೈವರ್ಸ್ ಡಿಗ್ರಿ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
ಇದ್ಯಾವ್ದು OS?
ಅದು OS ನಲ್ಲಿ ಅವ್ರಿಗೆ ಮದುವೆ ಆಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ನಾನು ಸ್ಟೇ ತಗೊಂಡಿದ್ದಿತ್ತು.
The decree of divorce is under challenge.
ಈಗ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡೋದಂತಂದ್ರೆ ಅವ್ರು ಈಗ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿ
The defendant is permanently restrained from contracting second marriage.
That's not under challenge.
Since of his marriage.
ಅದು ಚಾಲೆಂಜ್ ಇಲ್ಲ.
ಅದು ಚಾಲೆಂಜ್ ಅಲ್ಲ.
Decree of divorce is under challenge.
ಡೈವರ್ಸ್ ಮಾಡೋದು.
Decree of divorce is under challenge.
The husband had sought for divorce of decree.
ಹೌದು. ಹೌದು.
That was decreed.
Party allowed. Marriage solemnly dissolved by decree of divorce on the ground of cruelty. Claim of petitioner for dissolution of marriage on the ground of desertion
is rejected.
Respondent husband is no more.
No more. No.
ಅವ್ರ ಮದರ್ ಇನ್ ಲಾ ಇದ್ದಾರೆ, ಅವ್ರಿಗೆ ಬ್ರಿಂಗಿಂಗ್ ಆನ್ ಎಲ್ಲರ್ ಸರ್ ರೆಕಾರ್ಡ್ ಅಂತ
For
ಹೇಳಿ
what purpose?
ಫರ್ ಇದು ಟು ಇದ್ರ ಕಂಟೆಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಮೇಲೆ. ಈಗ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ನನ್ನ ಅಗೇನೆಸ್ಟ್ ಡಿಗ್ರಿ ಆಗಿದ್ದನು, ನಾನು ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡೇನ್ರಿ. ಹಸ್ಬೆಂಡ್ ಸತ್ತ ಬಳಕ ಎಲ್ಲಾರ ಅಗೇನೆಸ್ಟ್ ಅಂದ್ರ ಈಗ ಡೈವರ್ಸ್ ಡಿಗ್ರಿಯನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋ ಸಲಕ್ಕಾಗಿ ಟು ವ್ಯಾನಿಶ್ ದಿ ಸ್ಟಿಗ್ನಾ ಆನ್ ಮೀ. ಅದಕ್ಕೆ ಅವ್ರ ಎಲ್ಲಾರ್ಸ್ ರಿಕಾರ್ಡ್ ಅದ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ ಹೋಗ್ಬೇಕು ಮೇಲೆ ಡಿಲೇ ಕಂಡನ್
Notice issue ಮಾಡಿದ್ವಾ?
ಅವ್ರು ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ ಅವ್ರಿಗೆ, ಇವರೇ ಎಲ್ಲಾರ್ಸ್ ಅದಾರ ಇಲ್ಲ ಕನ್ಫರ್ಮ್
ಅಲ್ಲ, irrespective of that, ನಾವು what they have.
ಇಲ್ಲ ಅದು
ತಾಯಿ ಮತ್ತೆ
ತಾಯಿ ಒಬ್ಬರೇ ಬರ್ದಿದ್ದಾರೆ, ಬಟ್ ಅವ್ರು ಉಳಿದವರು ಸಿಸ್ಟರ್ಸ್ ಆರ್ ಆಲ್ಸೋ ಮಲಾಡ್ಸ್ ನೆಸೆಸರಿ ಪಾರ್ಟೀಸ್.
ಕೊಡ್ರಿ ಅಂತ ಇನ್ಫಾರ್ಮೇಶನ್.
Because malots, the what now by virtue of the bringing LRs on record, the decree of divorce granted, even if it is set aside malots only in respect of the consideration of the proprietary rights arising out of the malots, if the decree is set aside and if he is the maintained malots continue to be maintained as a status of widow.
Yes.
Then malots other legal heirs rights would be affected and they are also necessary parties. Unless they were brought on record, the only now they want to implead the mother of the respondent, deceased respondent.
As per my knowledge, the mother-in-law is only legal.
That judgment you want to rely upon? Which is the judgment you want to rely upon to bring the LRs on record in a matter like this?
ಸರ್ ಅದು ಇದಲ್ಲ, ಹಿಮಾಚಲ್ ಪ್ರದೇಶ 24th
ಇಲ್ಲ 24th ಕರ್ನಾಟಕದ ಡಿವಿಷನ್ ಬೆಂಚ್, ಕರ್ನಾಟಕದ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ಆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಎಂಟೈರ್ಲಿ ಡಿಸ್ಕಸ್ಡ್ ಅಂಡ್ ಹೆಲ್ಡ್ ದಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಇವನ್
Purpose of property rights.
ಪ್ರಾಪರ್ಟಿ ರೈಟ್ಸ್ ಅಲ್ಲ, ಓನ್ಲಿ ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಿ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ದಿ ಸ್ಟೇಟಸ್ ಆಸ್ ವಿಡೋ. Now what would happen, lords, if the decree of divorce is
ಯಾವುದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ?
ಇಲ್ಲ ಅದಿಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್. ಅವ್ರು ಹೋದ್ಸಲ ಒಂದು
ಕೊಟ್ಟಿದ್ರು, ಅದು ನನ್ಗೆ ಸ್ವಲ್ಪ ಬೇರೆ ಕೊಟ್ಟಿಂದ.
After the death of the husband, who is going to talk about that? I don't see any reason. If you are talking of cruelty on the part of the wife, that is the allegation
Against
made
the
by the husband.
ಹೌದು. I
A decree has been granted by the trial court now. Now after that, he is no more. For what purpose the LRs have to be brought on record?
Malords,
You are saying, no, there is a judgment of the division bench. ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಕೊಡಿ.
ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್.
Even if it is so, it may be for a limited purpose.
ಅಷ್ಟೇ.
It cannot be for consideration of the ground of cruelty.
ಹೌದು.
Not possible, because the person who succeeded is no more. Someone else can't come and defend that.
Cruelty against the husband, it can't be lords, transfer to the legal heirs. The list
Not
list and cause of action does not survive against the others.
Therefore, if it is for the consideration of that right, how it has to be considered?
ಇದರಲ್ಲಿ ಕ್ರೂಯಾಲಿಟಿ ಏನಂತದ್ದು ಮದರ್ ಇನ್ ಲಾನೇ ಪ್ಲೇಡ್ ಫ್ರಾಡ್ ಆನ್ ದೀಸ್ ಪಿಟಿಷನರ್, ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಒನ್ ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್ ಮೈ ಲಾರ್ಡ್. ಆ ಜಜ್ಮೆಂಟ್ ವಿತ್ ನಾನು ಅನ್ನೋದು ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಹೌ ಇಟ್ ಈಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಅನ್ನಂಥದ್ದು ಐ ವಿಲ್ ಶೋ ಮಿ ಲಾರ್ಡ್. ಇಲ್ಲ ಇದರಲ್ಲಿ ಇಷ್ಟೇ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಅಂತಂದ್ರೆ ವಿಡೋ ಅನ್ನಂತ ಇದು ಡೈವರ್ಸಿ ಅನ್ನಂತದ್ದು ಹೋಯ್ತು ಅಂತಂದ್ರೆ ಐ ಆಮ್ ಒನ್ ಆಫ್ ದಿ ಲೀಗಲ್ ಹಿಯರ್.
ಡಿಫೆಂಡ್ ಮಾಡೋದು
ಸರ್ ಅದು ಕ್ರೂಯಾಲಿಟಿಗೆ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದು ರೀ.
ಯಾರಿಗೆ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡೋದು? ಹೌ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಡಿಫೆಂಡ್ ದಿ ಹಸ್ಬೆಂಡ್?
Husband is no more.
The person who made the allegation and succeeded is no more.
ಇಲ್ಲ, ನಾನು ಅದನ್ನ ಹೇಳ್ತಾ ಇರಲಿಲ್ಲ. ದಿ ಅದರ್ ಗ್ರೌಂಡ್ಸ್ ವಿಚ್ ಹ್ಯಾವ್ ಕಾಂಟ್ರಿಬ್ಯೂಟೆಡ್ ಫಾರ್ ದಿ ಡೈವರ್ಸ್, ಈಗ ಗಂಡನ ಅಗೇನೆಸ್ಟ್ ಏನಂತದಿಲ್ರಿ, ಅದು ಕೋರ್ಟ್ ಅಬ್ಸರ್ವ್ ಮಾಡೋದು ತಪ್ಪದನಂತ ಅದು ಮೊದಲು ಎಸ್ಟಾಬ್ಲಿಷ್ ಆದ ಬಳಕ ಮೆಲಾಡ್ ದಟ್ ಆಸ್ ಪರ್ ತಾವ್ ಹೇಳೋದ್ ಪ್ರಕಾರ ಅದು ಕೌಂಟ್ ಆಗ್ತೈತ್ರಿ.
ಯಾರ್ರಿ ಡಿಫೆಂಡ್ ಮಾಡೋದು ಅವನ್ನ ಈಗ?
ಎಲ್ಲಾರ್ಸ್ ಮೊದಲ್ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಬಂದ ಬಳಕೆ ಅದು ಗೊತ್ತಾಗ್ತದೆ.
ದೇ ಡಿಫೆಂಡ್ ಆನ್ ದಿಸ್ ಗ್ರೌಂಡ್. If they don't have personal knowledge.
ಇಲ್ಲ, ಅವರು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ರು.
They come and
They have, the mother-in-law has also given evidence before this honorable court, before the lower court, my lord. Mother-in-law has given evidence and she has filed a complaint. ಅವಳ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಆಧಾರವಾಗಿ ತೆಗೆದುಕೊಂಡು ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ she got admitted in hospital. ಈಗ ಅವ್ರ ನಡುವೆ ಜಗಳ ಆಗಿದೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಇದು ಮದರ್-ಇನ್-ಲಾ ಅಪ್ಲಿಕೇಶನ್ ಅಂತಾರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದನ್ನ ಗ್ರೌಂಡ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಕೊಂಡು ಡೈವರ್ಸ್ ಡಿಗ್ರಿ ಆಗುತ್ತಿದೆ ಮೇಲೆ ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಡೈವರ್ಸ್ ಪಿಟಿಷನ್ ಅವ್ರ ಏನದ ಇದೊಂದು ಗ್ರೌಂಡ್ ಅಂದ್ರೆ ತಾಯಿಗೆ ಹೊಡೆದಿದ್ದಾಳೆ ಅವ್ರ ತಾಯಿಗೆ ಅನ್ನಂಥದ್ದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. ಅದು LCR ನಲ್ಲಿ ಬಂದಿದೆ ಮಲ್ಲಾಡ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕನ್ಸಿಡರ್ಡ್ ಆಸ್ ಎ ಕ್ರೂಯಾಲಿಟಿ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಅವರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡುವಂತ
ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವರು ಉಳಿದು ಲೀಗಲ್ ಏರ್ಸ್ ತರ್ಬೇಕಾ, ಉಳಿದು ಸಿಸ್ಟರ್ಸ್ ಕೂಡ ದೇ ವಿಲ್ ಆಲ್ಸೋ ಬಿ ನಾಟ್ ನೆಸೆಸರಿ ಪಾರ್ಟೀಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಡೆತ್ because under section 8 not even for consideration of the proprietary rights concerned they become necessary parties.
ಆ ರೀಸನ್ ಕಾಗಿ ಅವರಿಗೆ ಯಾರ್ಯಾರು ಅದಾರ ಒಂದ್ ಸ್ವಲ್ಪ ಇನ್ಫಾರ್ಮೇಶನ್
if the notice is issued my lords I will get the instructions that apart only the in view of the death of the husband the cause not survives only for consideration of the any permanent alimony if they want to settle it. I can not get the instructions.
That is subsequent. First he has to furnish. ಈಗ ಉಳಿದ legal ಹೇಳಿದ್ರ ಅಂತಂದ್ರೆ I will file a memo. At least he has to file memo. ಈಗ ನನ್ ಗೊತ್ತಿದ್ದ ಪ್ರಕಾರ ಮದರ್ ಇನ್ ಲಾ ಮಾಡೇನ್ರಿ. ಈಗ ಉಳಿದರು
last time we had directed you.
ಅದನ್ನೇ.
And you are not secured any instructions. ಎರಡೆರಡು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇದಕ್ಕೇನೆ ಆದ್ರೆ ಹೆಂಗ್ರಿ?
ಇಲ್ಲ ಅವ್ರಿಗೆ ಮಲಾಡ್ಸ್ they want to settle it even before the death
ಆಯ್ತ್ರಿ,
also.
ಫಸ್ಟ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಫಾರ್ ದಟ್ ಒನ್. You don't want to take instructions?
ಅಲ್ಲ I will ಮಲಾಡ್ಸ್ take I will get the wakalat.
Directed
ಅಲ್ಲ I will get the wakalat and file it in respect of the
ಇವಾಗ
other of the
ಬರೀ
deceased.
ತಾಯಿನ್ ಮಾತ್ರ ಮಾಡಿದಾರ?
ಅವ್ರೊಬ್ರನ್ನೇ ಮಾಡಿ.
ಅಟ್ ಲೀಸ್ಟ್ ಅವ್ರದ್ದು ವಕಾಲತ್ ಹಾಕಿ ಫಸ್ಟ್, ಆಮೇಲೆ ಯು ರೈಸ್ ಅಬ್ಜೆಕ್ಷನ್. Week's time is granted at the request of learned counsel Sri Mahantesh Patil. Secure instructions.
ಮಕ್ಕಳಿಲ್ಲ.
ಮಕ್ಕಳಿಲ್ಲ. ಮಕ್ಕಳಿದ್ರೆ
Secure instructions. In respect of IA number 1 of 2024, filed by the appellant. ಮಾಡಿ ಫಸ್ಟ್ ಅವತ್ತು ವಕಾಲತ್ ಹಾಕ್ಸಿ, ಆಮೇಲೆ ಯು ಕ್ಯಾನ್ ರೈಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಲ್ಸೋ.
Seal number 28, government advocate.
Set of appeals by the state and the crops by the contesting claimants are now subject to confined to section 74 of the new act. 74 prescribes the period of limitation. The coordinate bench of this court had earlier decided that there is no question of application of section 5 for the limitation act. This matter is now according to the state pending before the Supreme Court. In fact, earlier they had appealed. It was sent back to file review petition. The review petition of dismiss agide. Now it is again pending before. But the problem therein was that the acquisitions then were under the old act. The award was passed under the new act. Either num case nalli enagide, award has been passed under the acquisition is under the new act and award is also passed under the new act. Only there the defense of the state was that basic acquisition was initiated under the old act. So old act permitted the application of section 5 of limitation act. So for that reason, they say that 74 of this new act may not be applicable. But num case is very clear and straight.
That ಅದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಸೈಡೆಡ್ ಕೇಸ್ ಇತ್ತು ನೀವು ಕೊಡಿ.
ಇಲ್ಲ ಈಗ will have to how ಇಲ್ಲ right?
Only in respect of the new act.
New act.
You don't find judgments. What is which is provision ಕೊಡಿ.
74 of the right to fair compensation and transparency.
Allah, see, those are matters where the acquisition proceedings were commenced under the old act. Here it is not so.
It is all under new act.
Therefore, if everything is falling under the new act and the new act does not make provision for
appeal beyond the period of 6
why should we wait for that judgment?
That was the argument.
Not necessary.
The court framed that, my lord, issue on 4-9, your lordships may see the order sheet. The court, my lord, sought for an answer whether, my lord, we may have to wait for the judgment of the Supreme Court since it is falling under the new act. 4-9, my lord.
24-9.
No,
4-9.
4th of September.
Last time ಅದನ್ನ ಹೇಳಿದಾರಲ್ರಿ. It is for you to submit now.
That's why I'm not. Additional Advocate General is on the line.
Yes, Mr. Additional Advocate General.
My lords, the fact that this matter was listed today was brought to my notice last night, my lord. I pray for a short accommodation. And second thing, my lord, in my humble submission is
ಏನಾಗಿದೆ, your earlier contention was that there is a matter pending before the Supreme Court.
Please.
That was pertaining to cases where acquisition commenced under the old act.
Old Act, please.
Here, the acquisition, entire process of acquisition commenced under the new act only. So therefore, we did not have to wait for that judgment of the Supreme Court. We are only concerned with the provisions of the new act.
Please. My lords, my humble submission, my lords, would be in that matter, my lord, what had happened, the appeal was sought to be filed under section 54 of the 1894 Act. So why that new act and old act issue had come up in that particular case also was because the compensation was, the award was passed after the commencement of the new act, and by virtue of operation of section 24(2), the award, it was deemed that it was passed under the new act. It is not that the new act had nothing to do with that particular acquisition process. As my lords are aware, after the Indoor Development Authority and versus Manohar Lal's case, the acquisition under 24(2) comes into operation when there is no award is passed within 5 years, commencement of the new act. So
ಈ ಕೇಸಲ್ಲಿ ಅದೆಲ್ಲ ಏನು ಬರೋದೇ ಇಲ್ಲ ಅಂತ ಪ್ರಶ್ನೆ. The acquisition has commenced after the new act has come into force.
Please,
so therefore, the old provisions of the old act will not come into play.
Please, I bow to my lords. These aspects were already argued. I do not know if it was already brought.
No, in fact, this is what has been noticed.
Similar IMFS only. This aspect was argued. IAs have been allowed. My delay applications have been allowed in some of them.
Then that we'll have to reconsider ಅಷ್ಟೇ. ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದನ್ನ ನಾನು ಹೇಳ್ತೀನಿ.
Now that also question will arise now. If the law does not permit it, can the parties by consent condone the delay? They also cannot condone. So that order itself.
Appeal against the order before the Supreme Court, my lord. They can appeal against the order before the Supreme Court. The delay order, delay has been condoned. If they're aggrieved by it, then they can file an SLP before the apex court.
That, my lord, necessary application for recalling is already filed, my lord. That recalling file.
They have filed application to recall that order.
Recalling after my application is allowed, my lord, there is no provision to recall that order, my lord.
No. See, by misconception of law, if an order is passed.
My lords, it was heard at length. It was not by consent. They're misrepresenting with great respect.
Where is the reasoning? No reasoning at all.
By consent of both the parties?
No.
No, it is not by consent, please.
The consent illa.
Consent illa.
There is no detail.
Matter was heard not before 3 different benches, my lords. Before 3 different benches, matter was heard. Finally, an order was passed in this particular case and in similar other cases too. My lords, it is a different matter altogether whether the order is legally correct or otherwise. But to state that it was by way of consent is
if you have a copy of the order sheet, please see the order sheet dated 23/1/2020.
Please.
ಅದ್ರಲ್ಲಿ ಏನು ಡಿಸ್ಕಷನ್ ಇಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ.
ಅಲ್ಲಲ್ಲಿ ಇರಬಹುದು ಸ್ವಾಮಿ, ನಾಟ್ ಬೈ ಕನ್ಸೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. It was not by consent.
Even if it is by consent, the question is
permissible.
Can the law be overlooked and jurisdiction admitted by virtue of consent given by parties? Not possible.
My lords,
because it will have a lot of ramifications. ಹಂಗಲ್ಲ ಯಾವ್ದೋ ಒಂದ್ ಮ್ಯಾಟರ್ ಆತರ ಮಾಡ್ಕೊಂಡು ಮಿಕ್ಕಿದಕ್ಕೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಆಮೇಲೆ. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
My lords, the date may be fixed. My lords will argue the matter on that application of recalling which they have filed.
My submission, my lord.
But I would want this honorable court to take note of the fact that it's actually incorrect to state that order was obtained by consent of the parties.
Allah beda, see, let us not go by what is told at the bar. That is why I said we'll read the order.
Please, I bow to my lords.
Peruse the application and the affidavit filed in support of the application for condonation of delay. Peruse the ground urged in support of the application. Heard the learned additional government advocate appearing for the appellants and learned counsel for the respondents. The delay, in our opinion, is neither considerable nor extraordinary. it is contended that due to pressure of work, the law department granted approval to file appeal and conveyed it belatedly. Being satisfied with the cost shown, delay of 167 days is in preferring the appeal is condoned.
Please.
And my lord,
ಏನು discussion ಆಗಿಲ್ಲ ಇದ್ರ ಬಗ್ಗೆ.
Please.
Whether under the new act, application under section 5 can be filed and whether court can consider condoning.
That was not taken into consideration.
ಏನು ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ.
my lord, in fact, my lord, in this very
Please,
bad.
my humble submission, this argument was also made when they filed this application. We brought it to the
ನಾವೇನ್ ಮಾಡುದು
court
sir?
yesterday.
No reasons are given here.
Allala, Sari Swami, the appropriate forum is the Supreme Court, not this honorable court.
Condonation of delay when this was.
Ali,
of the court.
see, what, it is not a clerical nature, it is not a law.
Kept the, my lord, issue of delay, my lord, it was kept open.
That
and
is what we are doing now also.
Yes, yes. That is how, my lord.
That
it
we
is
have
done.
kept it open.
Lord, first few matters, my lord, where it was not brought to the notice. Court by, my lord.
ಅದೇ by oversight, neither the court knew about it nor the parties apprised the court about it, so orders were passed.
Lord, all said and done, my lord, my request is this, my lord. Your lordship, my lord, apart from the delay, also hear them on merits, my lord. It's not that case, my lord, I want to take an order, my lord, on technicalities. My lord, on merit also I have case. Difficulty is this, my lord. From last several years, several batch of matters are kept pending, my lord, on one or the other pretext, and my lord, it's a loss to the state as well, my lord. They are paying 15% interest. It is, my lord, harmful for the claimant as well. They don't get, my lord, their compensation. My lord, your lordship, hear them on merits also, my lord. Of the, my lord, it could be heard. If your lordship still find, my lord, there is a case, my lord, for them, then, my lord, the question of consideration of delay will come into arise. My lord, I am trying to make out a case on merit and also, my lord, on my lord, the position of law. Let them not dodge the matter, not saying, my lord, the matters are pending before the Supreme Court. It's pending, my lord, since long. And in the earlier round, it was remitted only on that count, my lord, that saying that whether 54 application, my
54
lord,
is applicable or something.
In the daily order dated 4/9/2024,
in some of the matters.
in MFA 202276 of 2019 and connected matters, this court noticed the submissions made on behalf of the appellant claimants
Respondent
claimants regarding condonation of delay beyond 120 days and it was noticed that the decision in the case of Deputy Commissioner versus Messrs. SV Global Mill Limited in MFA number 3806 of 2019 may not hold good for the present cases, since the issue now pending consideration in these appeals all arise only under the new act.
Yes.
Full stop. Whereas in Deputy Commissioner bracketed Supra, Messrs. SV Global Mills Limited Supra, that question was gone into since part of the cause of action arose under the old act and the award was passed under the new act. Full stop. However, that is not so in the present scenario. Full stop. Therefore, the learned additional government advocate was directed to secure instructions and make submissions. Full stop. Next para. However, it is pointed out that in MFA number 202276 of 2019, interim orders have been passed by this court condoning the delay Full stop. Learned counsels for the respondents, however, submit that an application to recall that order has been filed by the respondents,
Wherever delay is condoned.
comma, since such delay could not be condoned. In view of the express provisions contained in the new act.
74, section 74.
Section 74 of proviso.
Section 74.
74 of the new act.
Right to fair compensation and transfers.
Next para. So you have also filed cross objections.
Yes,
He has filed cross.
Seeking enhancement.
seeking enhancement.
Enhancement.
I have filed not separate appeals which are in time. My set of
One
matters,
set
my
of matters have been filed, they have filed MFA, which is again within time.
they
174.
become-
One set of matters, we have filed only cross objection.
There also delay in filing the cross.
There is also
That is
delay.
also.
Our-
28.11.
MFA goes, the
My lord,
cross
my
also
lord.
goes automatically.
ಹೋಗುತ್ತೆ.
Automatically.
That is pending, my lord.
Landlords and states, both applications were condoled, my lords. Application, delay applications.
ಅದೇ,
delay was condoled.
in all those matters, if this court were to hold, there is no such scope for filing an application under section 5. Then if the main order goes, then the orders, the cross of objections also will go.
Please, please, please.
So to hear only on this aspect of the
But-
matter.
And also on
And
merits.
also on the merits of the
merits, my
matter.
lord, we'll address that.
We'll address
because,
arguments on merits. If the court for any reason comes to a conclusion that they have a case for reduction upon them, then the question of consideration whether 74 apply athodaniಲ್ಲ ನೋಡ ಬರ್ತಾ. Even otherwise also on merits also the court can dismiss their appeal.
and
At that time, there is
on
74.
both count, my lord, they may. Alla, I understand.
ನಾವು delay condone ಮಾಡದೇ ಇದ್ರೆ we don't get jurisdiction.
My lord, your lordships will get jurisdiction in my appeals. My
ಅದೇ,
appeals are in time.
ಅಷ್ಟೇ ಅಷ್ಟೇ.
If your lordships allow my appeal, there is no question of my lord, there, my lord.
Of course. It
Maintain
cannot
those-
be allowing the claimant's appeal for enhancement and allowing the appeal of the. ಬರೋದಿಲ್ಲ, ಹಂಗ್
Alla,
ಆಗಲ್ಲ.
what I request is let the state come prepared for appeal, my lord, main as well, my lord, so that this, we go, my lord, forward. We are, my lord.
Next para. Learned additional advocate general is requested to come prepared to argue not only on the question of condonation of delay on the applications filed by on behalf of the state, SLAO on the state, but also on the appeals filed by the claimants.
Merits of the matter.
merits of-
Release this matter, release these matters. ಯಾವಾಗ? We'll have it on 11th.
12th.
My lord, 21st, my lords. Lord, there are not one, my lord, may draw my lord's kind attention. I think there are more than, I think now we have crossed around 500 to 600 MFAs, my lords, all on the same acquisition. Same acquisition.
ಆಯ್ತು.
all the-
ಇದನ್ನ ಆನ್ಸರ್ ಮಾಡಿದ್ರೆ they will all
ಅಷ್ಟೇ,
follow.
ನೀವು ಎಷ್ಟೇ ಮ್ಯಾಟರ್ಗಳು ಎಷ್ಟಿದ್ರೆ ಏನಂತೆ, only the substance will be the same.
Remains the same.
ಅಲ್ಲಲ್ಲ, ಅದ್ರಲ್ಲಿ of course, as my lords are aware, ಬೇರೆ villages, ಬೇರೆ ಇದು considerations will change, nature of property would be different, distance from ಎಲ್ಲಾನು factual aspects ಬಹಳ examine ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ.
ಅದೇನು ಅಂದ್ರೆ ಈ ಟರ್ಮ್ ಎಂಡಿಗೆ ಹೋಗ್ತಾ ಹೋಗ್ತಾ ಇನ್ನು ನಮ್ಗೆ ಕಷ್ಟ ಆಗೋಗುತ್ತೆ.
ಇಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರ್
ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ಮಾಡಿದ್ರೆ
ಬ್ಯಾಂಗ್ಳೂರ್ my lords can
Start
hear
ಮಾಡಿದ್ರೆ ನೀವು
Bangalore, my lord.
ಒಂದ್ 2-3 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರು ಪರವಾಗಿಲ್ಲ, ನೀವು ಆಮೇಲೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ one batch of cases, my lord, if this is addressed and answered, my lord, one will be, my lord, the technical issue of maintainability of appeal, my lord, beyond
Actually,
120 days.
will have
That
to
will
be
apply
heard,
to
my
other
lord.
cases. Whereas, my lord, determination of value will apply only to this batch of cases. There are no other, my lord, cases. They are on a different context, my lord. I request for 12th or 13th, my lord, if it is convenient,
no, my
or else,
lord.
my lord, 19th, my lord, at least. Because if
But
it-
I'll have to get secure instructions, my lords. Appeals have been filed more than a year ago. Bala matters ಇದೆ. My learned friend will have the my learned friend will have the assistance of his clients and a battery of lawyers in his office. Government counsel ತಮಗೆ ಗೊತ್ತಿದೆ. ನಮಗೆ ಆ ತರ ಅಷ್ಟು ಲಕ್ಸುರಿ ಇರಲ್ಲ.
Our client will ಏನ್ರಿ ಹೇಳ್ತಾರ ಪಾಪ ನಿಮ್ಗೆ you have
ಇಲ್ಲ,
experienced legally trained persons with you. ಅದನ್ನ ಬಿಟ್ಟು ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳ್ತೀರಾ.
Land acquisition matters nowadays, clients are smarter than lawyers, my lord.
We will have it on 12th of November. You please come. 12th of November.
My lords will hear us on the maintainability also.
Yes, yes.
Please.
Yes. Great.
Please.
This appear for the complaint in this matter. Say number 29.
My lords, in this case,
ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಬರೆದಿದ್ದಾರೆ ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲಿ.
Yes, my lord.
my lords, in this case, a review petition has been filed. My lords, the back.
ನೋಡಿ ಮಿಸ್ಟರ್ ಆ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಧಾರವಾಡ has decided this issue.
On my lords are addressing me, my lords.
ಹೌದೌದು ನಿಮ್ಗೆ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಐ ಆಮ್ ಟಾಕಿಂಗ್ ಆಫ್ ದಿ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್.
MFA, my lords.
MFA.
Please, my lord.
Please note down. ನೀವು ಬರ್ಕೊಳ್ಳಿ. MFA number 102543. Mr. This is that question of previous matter has been decided by a division bench at Dharwad.
Of which, of year, my lords?
MFA 102543 of 2022.
Please.
Dated 23rd of September 2024. 23rd of September 2024.
24, please. I'll go through it. I'll go through it and make my
issue is already decided.
Please, please. My lords, in the another matter earlier to my matter, my lords, with regard to that matrimonial matter, where my lords were asking, the judgment is Jyoti versus Sarvana, my lords. That is the case. Judgment decided.
ನೋಡಿದೆ ನಾನು. I saw that judgment.
So please.
See, ನನಗೆ somehow I am a little I am not very satisfied.
Please, please.
See, the issue is regarding divorce between two spouses.
Please.
The matter has been decided.
Please.
A decree of divorce has been granted.
Granted.
The person who succeeded,
Please.
thereafter dies.
Dies. True.
The Supreme Court has said, no, the right to sue would survive. Although it will be only for the question of the division of the estates of the deceased person.
Deceased person. True.
Adre, what should happen to the main matter, main issue?
Main
Who is
issue.
going to defend that dead person?
Dead person. True, my lords. I bow to my lords. I agree. I agree. That's
But anyway, that is the 1997.
Yellava versus Shantava.
Correct. Yellava versus Shantava.
Please.
Correct.
Please.
ಹೇಳಿದ್ದಾರೆ. But anyway, we are sidetracking the main matter itself. The question of she coming out unscathed or without any blemish, that main matter, who's going to defend? The husband. And these are all personal information, something that has been spoken by the husband
Yes.
against the wife, or the wife against the husband. Adana, how can the LRs come and defend? Anyway, this judgment, so yen madakagalla. Yes.
CL number 29, Ganesh is.
My lords, in this case, my lords, this matter pertains to acquisition of land for the purpose of construction of jail premises in Bidar city, my lords. The petitioner, the complainant was the petitioner, my lords, who claimed that compensation was not handed over to him, whereas these other site holders in the same premises were given the compensation. It was appealed against by the state. It was dismissed, my lords, and the same was preferred on the ground of delay. Our appeal was dismissed. We had taken it to the Honorable Apex Court. The Apex Court remanded the matter to permitting us to file revision. Revision has been filed before this Honorable Court, and notice has been ordered, my lords. And I'm not sure if the complainant has filed his wakalat in that matter, but notice has been ordered, and the matter is slated for hearing in the next week. Next week or the week after that.
Learned single judge.
Single judge ಅವ್ರ ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ. ಹೌದು ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ factual aspects, we brought it to the court's honorable court's notice that he was not the original, his name did not appear in the acquisition notification, 1. 2, that he was a subsequent purchaser, so he did not have a right to challenge the acquisition. On certain other grounds, we had challenged it, my lord. So we have been reverted to.
The matter was remanded, my lords, for review only at the point whether possession has been taken or not, my lords. All these aspects have been dealt, my lords. And 6 time was given, my lords, on
Anyway,
22/7.
we will have to await the decision of the learned single judge.
Please, my lords.
So till then, we'll have to keep this in abeyance.
Please, my lords. The chief has, my lords, ordered that within 6 weeks, my lords, they have to pursue the review, my lords. 3 dates they have taken in review petition, my lords.
Learned additional advocate general submits that the respondents had taken up the matter before the apex court, and the apex court has remanded the matter back to the learned single judge. And the apex court permitted the respondents to
Refer a review.
File a review petition.
File a review petition.
Review petition. And the aspect of possession, my lords.
Full stop. Accordingly,
No.
a review petition has been filed by the respondents before the learned single judge. Full stop. Learned AAG would therefore submit that the matter may be kept out of circulation till the matter is decided, the review petition is decided by the learned single judge. Full stop. Next part. Accordingly, office is directed to keep this matter out of circulation. Full stop. Liberty is reserved to the learned counsels to move a memo once the matter has been, the review petition has been decided by the learned single judge.
Much obliged.
CL number 30, government advocate.
In this matter, my lord, keeping the IA for recalling the, my lord, condemnation delay and also recalling the dismissal order, my lord, we may be permitted to comply the office objection.
Pending consideration of IAS number 3 and 4 of 2023, the appellants are permitted to comply with the office objection.
Please. Same, my lord, 31, 32.
31.
32 also.
32.
Yes, same.
Same.
CL number 32. CL number 33. Siddharuda B. Pujari.
Or petitioner. My lord, I have challenged the order passed by the tribunal, my lord.
I am for respondent, my lord. Kindly have it on Tuesday or Monday. Certain documents I need to be produced.
At the request of learned counsel for respondent number 5, release this matter on 5th of November.
Obliged.
CL number 54, Chaitanya Kumar Chandriki.
But I'm looking for the appellant in this matter, not the suspension of, I filed application for suspension of sentence. He has been convicted and sentenced to undergo imprisonment for life. objection is not filed. My submission, my lord, the records may be called for me. Records, trial court records may be called for me, which is necessary to adjudicate the application for suspension of sentence.
Call for trial court records.
CL number 36 preliminary matters. Duru Satyanarayana.
Petition filed against the order passed by the respondent administrative tribunal, my lord. The applicant was, petitioner was appointed as lecturer, part-time lecturer in 1/8/2019. And he was under the special forces circumstances, after waiting for quite long time of rendering service of 17 years. Under depression, he's rendered a resignation. And it was accepted on 13/12/2007, and he was relieved on service from service. As per the direction of the Honorable Supreme Court, in case Mahalingagoda and others directing absorption of part-time lecturers, direction was given to the government to consider the claim of these petitioners and others. And rules were not framed then till 2012. In 2012, the rules were framed and the petitioner made an application in 2013. And his application was not considered. And again, second application was made in as per A5. That application was also not considered. Ultimately, he filed a petition before the application before the tribunal. And tribunal, without appreciating the facts, they dismissed the petition application on delay aspect, on the ground that, on the defense taken by the respondent that
no interim relief can be given.
No interim relief, my lord. It can be taken up for final hearing.
Learned government advocate takes notice for all the respondents.
Yes. Yes, ma'am.
Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned government.
Yes, ma'am.
38 Uliappa Irul. CL number 38.
37.
That is housing board matter, my lord.
Aita.
Lordship has rendered one judgment relating to this aspect. The Lordship has authored that judgment. It's a specific date may kindly be given so that.
Yavdo, Mysore. Yavdo.
Navendra. Application. It's a for terminating his services. He has turned verge of retirement. A question of reinstatement doesn't arise. At least the relief is calculated in terms of money value that if it flows from the order of the Supreme Court. For regularizing that would work for.
That was only to consider the
Assist.
representation.
That's all. Because they are stopped from contending other delay aspect. It is their duty to consider.
But you are admitting that from in 2007 itself you.
No, admitting as force, he has become gone in depression because of the considering his application. And those and his wife filed a representation that he has gone mad, and it cannot be considered. In spite of that, he was relieved.
See,
my submission is.
This order was passed.
It was on duty of the government to consider the application because he had rendered 17 years of service. So he should have been.
Yeah, all this, these orders that I had passed.
Yes.
All stem out of one order that I had passed regarding the guest lecturers at Mysore University.
Yes.
That was a case where I had issued directions to the university to regularize the services of the guest lecturers.
Yes. This is a case of regulation only. This is a case of regulation because he was direct party to it.
Eitherly, I only directed consideration of the representation. But you see that judgment of Mysore University guest lecturers.
Yes, ma'am.
You may get something.
Yes.
Let's see.
Date may kindly be given.
ಇಲ್ಲ ಎಲ್ಲಿ ಅವ್ರು ಇನ್ನೂ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಲೆಟ್ ಅಸ್ ಸಿ. ಎಸ್.
CL number 38, Ilepayaru.
Very for respond number 4, my lord. I am for petitioner, lord.
Yes.
Other side has taken time to file objection. Caveator.
ಹಾಕಿದಾರಾ?
ನಾನು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಆಯ್ತು ಆಯ್ತು.
ರೆಡಿ ಮೇಡಮ್.
ಹೇಳಿ. ಎಸ್ ಹೇಳ್ರಿ.
Sorry, ma'am. Sorry. Lord, petitioner is working as a Tahsildar of Kalaburagi as a grade 1 Tahsildar as per the transfer order. My lord, I pray for password. 5 minutes. 5 minutes. Password. I pray for password.
ಯಾಕೆ?
ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತಾರೆ.
ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೇನೆ, ಟೈಮ್ ತಗೊಂಡೇ ಇಲ್ಲ ನಾನು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಆನ್ ದ ಲಾಸ್ಟ್ ಅಕೇಶನ್ my lord,
I'll argue 5 minutes.
My lord, I'll submit the facts, my lord. I'll submit it for lordship permits. I'll submit the facts, my lord, because I am the
Anyway, it is his petition.
yes.
He wants to say something, let him say.
Please.
We will hear it day after tomorrow.
Yes. No, sorry. Day after I'm out of station. Tomorrow.
Tomorrow.
Yes.
All right. Release this matter tomorrow.
Stay, my lord, expect.
Interim orders passed earlier stand extended till the next date of hearing.
Great.
Number 23, government.
Notice ಆಗಿಲ್ಲ.
Anyway, let us see. Preliminary hearing again, it will be coming up tomorrow. We'll see.
Admission matters, CL number 39, government advocate.
This may be.
Petition matters.
This matter has to be
39.
heard, my lord. This matter has to be heard, my lord, regarding regularization of the service, my lord.
2022 ಆಗಿ ಅಂತ ಅಡ್ಮಿಷನ್ ಬರ್ತದೆ ಇವಾಗ.
Post for hearing. Lordship may post this matter for hearing.
This arises from learned single judge.
Yes, ma'am.
Yes, sir.
Writ petition.
Yes, sir. Yes, please, ma'am.
List these matters for final hearing. On 21st of November.
CL number 40, DP Ambekar.
My lord, after receiving the TCR, this matter may be taken, my lord. After securing TCRs, this matter may be taken. My lord.
After securing
TCR, my lord, awaiting TCR, my lord.
CL number 40.
awaiting for TCR. Trial court records. Office is directed to secure the records from the learned principal district judge, Bidar, EAT number 1 of 2019, as was directed on 29 2024.
Seal number 41.
For the
Ratnayan Shiva argument.
This matter is, and also you filed the application for prosecution of this appeal, my lord. We also grant 1 week time, my lord, we get the instruction and file the necessary objection to this one. Whether he is a necessary party or not.
The original claimant was died after disposal of the petition, my lord. Thereafter, the appeal is preferred. After disposal, the claimant was died.
After disposal of
LAC. The claimant petitioner was died, my lord. Therefore, we have filed a application for permission to prosecute as a loss of the deceased petitioner appellate.
The same question regarding condonation of delay would arise here.
But there is a only part filing the, yes, but there is also my lord.
ಇದೆಲ್ಲ ಪೂರ್ತಿ ಓಲ್ಡ್ ಆಕ್ಟ್
ಹೌದೌದು. Old act, old act.
ಓಲ್ಡ್ ಆಕ್ಟ್.
Old act ನಾನು ಮಾಡ್ಬೋದು.
ಹಾ.
But that's why I get the instruction, my lord. Whether there is any dispute regarding the LRs and all, we are seeking the seeking permission to prosecute. But that is the reason I'll get the information from the.
ಈ ಅಪೀಲ್ ಜೊತೆಗೆ ಅದು ಅಪ್ಲಿಕೇಶನ್
ಜೊತೆಗೆ
ಪರ್ಮಿಷನ್ ಹಾಕಿದಾರಾ?
Yes. IA1 for 23 is the permission to prosecute.
Learned government advocate submits that he should be permitted to secure instructions regarding IA number 1 of 2023 filed by the appellants seeking leave of this court to prosecute the appeal
Please.
on behalf of the original claimant. It will stop. Release this matter on 7th of November.
Copy is not served on us. There is a direction to take notice not on 25/10.
ಕೊಡ್ರಿ.
Sir, under copy. I will see you under.
ಕೊಡಿ. Yes.
Seal number 42, Babu H. Metagudda.
Yes, of death, my lord, payment appeal for enhancement. Only, my lord, income is taken on 7,000 instead of 10,250 and 25% future prospect. Only.
ಯಾವ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ?
Muhammad Abdul.
ಅಬ್ದುಲ್ ಕೈಮ್ ಆನ್ಲೈನ್ ಬರ್ತಾನ ಅಂತ ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ. ಓನ್ಲಿ ಡೆತ್ ಕೇಸ್ ಇದೆ ಮೇಲೆ ಆಸ್ ಪರ್ ಚಾರ್ಟ್ ಮಾಡ್ಬೋದು.
Matter is called out. There is no representation for the respondent. Release this matter on 7th of November.
Seal number
One
43.
request. Seal number 26 ಬೇರೆ ಡೇಟ್. ಸೊ 26 ಮೇಲೆ 6 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು ಬೇರೆ ಡೇಟ್ ರಿಕ್ವೆಸ್ಟ್.
7th?
ಹಾ 7th ಕೊಡಿ.
7th.
ಆಯ್ತು.
Serial number
26.
ಆಯ್ತು.
Seal number 43, PS Mali Patil.
My lord, in this case, my lord, I am offering for the client, my lord. Last date of hearing, my lord.
Matter is called out. There is no representation for the appellant.
Yes,
Yes, Mr. Mali Patil.
My lord, in this matter, my lord, last date of hearing, my lord, this honorable court has directed the government.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
My lord, it is audible, my lord.
ಏನೋ?
It is audible, my lord. It is.
ಹೇಳಿ ಇವಾಗ ಹೇಳಿ.
My lord, pending see, my lord, last date of hearing, my lord, order, my lord, this honorable court has directed the government. The record, pending see, my lord, last date of hearing, my lord, 25/9/2024. The learned PS Malipad Learned Pass in the writ appeal number so and so.
Inquiry once forwarded to the government, it is the government to take final decision regarding punishment to be imposed, and the Lokayukta does not have the power to recommend imposition of any particular punishment. Learned government advocate is to secure necessary records to demonstrate that the decision arrived at regarding imposition of penalty is independent of the recommendation of the Lokayukta.
That is the, my lord, contention of other side, my lord. Recommendation, it is only made the recommendation, that's all, my lord. Whether it is considered or not, my lord.
ಅದಕ್ಕೇನೆ what you will have to place material ಅಂತ ಕೇಳಿದ್ದಾರೆ.
Get the entire file, my lord, the disciplinary authorities.
Last time a direction ಕೊಟ್ಟಿದ್ರಲ್ರಿ.
I'm written letter to the, my lord, to the principal secretary.
Government advocate seeks for a short accommodation to comply with the directions issued on 25/9/2024. Secure records and to place before this court. Stop. Release this matter on
4th or 6th, my lord, anyone next to you.
6th of November.
Please.
Seal number 44, K. Ravi Shankar. Seal number
Matter is called out. There is no representation for the appellant. Release this matter on 11th of November.
Seal number 45, additional government advocate.
She is behind 120 days. IA for CD may be kept open, my lord, and IA for
I am
stay.
undertake to file ವಕಾಲತ್ in this case. ಗೊತ್ತಲ್ಲ? I am undertake to file ವಕಾಲತ್. Learned counsel Shri
Sanganagowda V. Biradar.
Sanganagowda V. Biradar undertakes to appear for the respondent claimant. Huh? Same orders are the keeping open the question of delay. Yes.
Please.
Seal number 46, A. Kalaburagi.
Matter
Number
is called out.
46.
There is no representation for the appellant. Release this matter on 11th of November. Right.
Seal number 47, Prashant P. Vajantri.
My lord, the appellant, my lord, in this case, yes. My lord, in this case, my lord, the respondent issued the notification for the call for the Anganwadi assistant post, my lord. So the appellant and respondent number 9 has both are filed in the same post, my lord. So in the meantime, my lord, the provision list is published. The provision list published, my lord. In the provision list, my name is not there, my lord. So ninth respondent's number is published in provision list. On that reason, my lord, I will objected the provision list, my lord, before. So after that, ninth respondents also filed an objection. The both objection was clarified that the genuinity of the documents which has produced in the recruitment committee, my lord. So after the obtaining from the inquiry report, so final list was published in my name, my lord. So that list was challenged before the single bench, my lord, in the ninth respondent, my lord. That is allowed, my lord. Yes. So that is challenged. At the cost of repetition, respondent number 9 did not upload her ninth marks card and even not stated that she studied up to the 9th standard, having certain marks. During hearing her objection to his provisional list, the authority has no right to consider her 9th standard marks and hold that the respondent number 9 is more qualified than petitioner and consider her name for appointment. This is the ground. Yes. My lord, there are, my lord, at the time of applying the both, my lord, respondent number 9 and respondent number appellant, my lord, there are did error, my lord. ಅವರುನು ಕೂಡ ಎಂಟರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎಟ್ ದ ಟೈಮ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಅಪ್ಲೋಡಿಂಗ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವರುನು ಎರರ್ ಮಾಡಿದಾರೆ, ಮೆಲೋಡ್. ಮೆಲೋಡ್ ಸಿ ಮೆಲೋಡ್ ಅವ್ರದ್ದು ಮಾರ್ಕ್ಸ್ ಟೋಟಲ್ ಮಾರ್ಕ್ಸ್ ಮೆಲೋಡ್ ಮೆಲೋಡ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9th ಮೆಲೋಡ್ ಅವ್ರದ್ದು ಮಿಡಲ್ ಎಕ್ಸಾಮ್ದು ಮತ್ತೆ ಫೈನಲ್ ಎಕ್ಸಾಮ್ದು ಮೇಡಮ್ ಕೂಡಿಸಿದ್ರು ಕೂಡ ಅವ್ರದ್ದು ಮಿಡಲ್ ಎಕ್ಸಾಮ್ದು 327 and ಫೈನಲ್ ಎಕ್ಸಾಮ್ ಇಸ್ 257, ಮೆಲೋಡ್. My exams, my lord, middle. Please understand what the reasoning is of the learned single judge. Yes, my lord. That you did not even say. Yes, my lord. In your application. Yes, that you have passed 9th standard and you have got so much of marks. Yes, my lord. Yenu helilla ನೀವು application ಅಲ್ಲಿ. No, my lord. Therefore, how did the authorities consider your 9th standard marks is the question. No, my lord. ನಾನು ಅಲ್ಲಿ application ಹಾಕಿದ್ದೀನಿ. ಅದಾದ್ಮೇಲೆ ಅದನ್ನೆಲ್ಲ ವೆರಿಫೈ ಹಾಕಿದಿರಾ ಇಲ್ಲ ಅನ್ಲಿಲ್ಲ. ಅದರಲ್ಲಿ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಸ್ಟೇಟೆಡ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಪಾಸ್ಟ್ 9th standard ಆರ್ ವಿತ್ ದಿಸ್ ಮಾರ್ಕ್ಸ್. ಸಿ ದ ಮೈ ಲೋರ್ಡ್ ಮೈ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ಸ್, ಮೈ ಲೋರ್ಡ್. ರೀ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನೋಡೋದಲ್ರಿ, ಅಪ್ಲಿಕೇಶನ್. Yes, application, my lord. Please show your application. My lord, 36, my lord, annexure C, my lord. 36. Is your application? And annexure C, my lord. 36, sir.
Oh, annexure C.
Huh? Annexure C, my lord.
36.
61, my lord. Sorry, my lord. Page number 61. Yes, my lord. Yes. ಇಲ್ಲಿ my lord, education qualification is A standard ಅಂತ ಆಗಿದೆ. Education qualification is 10th standard. 8th standard ಅಂತ ಇದೆ, my lord. Page number 61, annexure C. Yes, my lord. Sudharani. Educational qualification. Yes, my lord. 10th standard ಅಂತ ಇದೆ ಇಲ್ಲಿ. Somewhere.
ಇಲ್ಲ 8th standard.
8th standard, my lord. ಅದು 8 ಅದು
Yes, my lord. Yes, standard.
ಎಕ್ಸ್ ಅಲ್ಲ 8
Excel. 8 standard, my lord. Here is.
therefore
ಇಲ್ಲ ಹಂಗಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ ಇವಳದು ರೂಲ್ ನಂಬರ್ ಈಸ್ 8 ಮೈ ಲಾರ್ಡ್. ಸೈಬರ್ ಕಾಫಿದವನು ಮಿಸ್ಟೇಕ್ ಮಾಡಿ ಅದನ್ನ 8 ಸ್ಟ್ಯಾಂಡರ್ಡ್ 9th ಹಾಕೋದ್ಬಿಟ್ಟು 8 ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಹಾಕಿದ ನಮ್ಗೆ. This is the error, my lord. At the time of uploading the mentioning the documents in the applications, my lord, he made an error that his rule number is 8, my lord. He is the 9th standard, my lord. See then, my lord, for the supporting that, my lord.
ಅಲ್ಲ ರೀ, ಇದು ನೀವು ಅಪ್ಲಿಕೇಶನ್
Yes, my lord.
ಒಪ್ಕೋತೀರಾ ನೀವು?
ಒಪ್ಕೋತೀನಿ, my lord.
You are shown 8th standard.
Yes, sir. By mistakenly, my lord. By mistakenly error, my lord. Nan mistake ಆಗಿದೆ, my lord. Admitted that the showing that I already completed 9th matter, but at the time submitting the applications, the cyber coffee is ಅವನು 8th standard ಅಂತ ಹಾಕಿಬಿಟ್ಟಿದ್ದಾನೆ.
ಅಷ್ಟೇ, that is what the judges found fault. Mentioned 8th standard.
Yes, my lord.
How is it possible for the officers to
Yes, my lord.
consider
Yes,
your
my lord.
9th standard marks ಅಂತ?
Yes, my lord. My
That is
lord,
the-
see the notifications, my lord. Page number, my lord, my lord. My lord, candidates events, my lord. First ಯಾವ ತರ ಮಾಡಬೇಕು ಅಂತ ಇದೆ, my lord. Page number 39, my lord. ಆನ್ಲೈನ್ ಅರ್ಜಿ, my lord. ಅದಾದ್ಮೇಲೆ ಆನ್ಲೈನ್ ಕೊನೆಯ ಲಾಸ್ಟ್ ಡೇಟ್, my lord. ಆಮೇಲೆ ಆಯ್ಕೆ ಸಮಿತಿಯ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಪಾಲಕರಿಂದ ಸ್ವೀಕರಿಸಲಾದ ಅರ್ಜಿಗಳನ್ನ ಪರಿಶೀಲನೆ ಮಾಡೋದು. ಆಮೇಲೆ ಅರ್ಹರಾದ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯನ್ನು ಆಯ್ಕೆ ಸಮಿತಿಯಿಂದ ಅನುಮೋದನೆ. ಆಮೇಲೆ
ಏನು ಮಿನಿಮಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನು?
9th, madam. 9th, my lord.
9th?
Yes, madam.
Minimum qualification.
9th, yes, 9th, madam.
Then when you have said 8th standard, your application should have been rejected. Please. ಅಲ್ವಾ?
ಇಲ್ಲ, my lord, at the time of objection, my lord, ನಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತಲ್ಲ ಅವ್ರ ಮುಂದೆ ಅಪ್ರೋಚ್ ಆಗಿದ್ದೀನಿ, my lord. ನಾನು 9th standard ಬಿಟ್ಟು ಕಲ್ತಿದ್ದೀನಿ, ಬಟ್ ಅಲ್ಲಿ ಎಂಟರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಐ ಅಪ್ರೋಚ್ಡ್, my lord. ಸೊ ದಟ್ ಟೈಮ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 9 ಅವ್ರು ಏನ್ ಕಂಡೀಷನ್ ತಗೋತಾರೆ, ನನ್ನ ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಗಳು ಜೆನ್ಯೂನ್ ಇಲ್ಲ, ಇವ್ರದೆಲ್ಲ ಫೇಕ್ ಅದಾವೆ ಅಂತ ಇವರು ಕೂಡ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತಾರೆ, my lord. ಸೊ ಇವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ, ನಂದು ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಕಮಿಟಿದವರು ಬಿದವರಿಗೆ ಒಂದು ಲೆಟರ್ ಬರೀತಾರೆ, my lord. ಇವ್ರದ್ದು ಯಾವ ಅಪ್ಲೈ
ಅವ್ರದ್ದು ಏನೇನು ಡ್ರಾಬ್ಯಾಕ್ ಇತ್ತು ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ?
ಸರ್, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಡ್ರಾಬ್ಯಾಕ್ಸ್ ಇದೆ, ಮಾರ್ಕ್ಸ್, my lord.
ಎಲ್ಲಿದೆ
ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ಸ್, my lord?
ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ?
Next shall be, my lord.
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ you are also required to submit the documents.
Yes, my lord.
So you have submitted 9th standard marks.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, 9th sem ಎಲ್ಲ 9th sem ಕೊಟ್ಟಿದ್ದೀನಿ.
Where do you get that?
ಸೊ ದಟ್ ಇಸ್ ಗೌರ್ಮೆಂಟ್ ಅವ್ರ ಕಡೆ ರಿಕ್ರೂಟ್ಮೆಂಟ್. ಅಲ್ಲ, ಅವ್ರ ಕಡೆ
ಅಲ್ರಿ, ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಕೇಳಿಲ್ವೇನ್ರಿ?
ನಾನು
ಇವಾಗ ಅನೆಕ್ಷರ್ ಬಿ ನೇ ನೋಡೋಣ. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್.
ಎಸ್ ಮ್ಯಾಮ್. 58
ಏನು ಇದ್ರಲ್ಲಿ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ?
ಹೌದು.
ಅಂಕಗಳು
my lord, ಅವ್ರದ್ದು 584 ಅಂತ ಹೇಳ್ತಾರೆ.
Marks obtained 584.
ಎಸ್, my lord.
Total out of 725.
ಇಲ್ಲಿ, my lord, ಅವ್ರದ್ದು 5 ಈಗ ಎರಡು ಕೂಡಿಸಿ ಹೇಳಿದಾರೆ, my lord. ಅವ್ರದ್ದು 9th ಮಾರ್ಕ್ಸ್ ಕಡೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವ್ರದ್ದು 584 ಹೇಗಾಗುತ್ತೆ, my lord? ಇಟ್ ಇಸ್ ದ ಸೆಮಿಸ್ಟರ್ ವೈಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್. ಸೆಮಿಸ್ಟರ್ ಫಸ್ಟ್ ಸೆಮಿಸ್ಟರ್, ಸೆಕೆಂಡ್ ಸೆಮಿಸ್ಟರ್, my lord.
ಯಾವ್ದು 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್?
ಎಸ್, my lord.
9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇಲ್ರಿ ಸೆಮಿಸ್ಟರ್ ಸಿಸ್ಟಮ್.
ಇಲ್ಲ.
ಏನ್ ಹೇಳ್ತೀರ್ರಿ?
Yearly and half yearly and yearly, my lord.
ಇಲ್ಲ, my lord.
Half yearly and yearly.
Half yearly and yearly, my lord.
ಏನು
ಮಿಡಲ್ ಅವ್ರದ್ದು 584 ಅಂತ ತೋರಿಸ್ತಾರೆ, my lord. ಸೊ ಅವ್ರಕ್ಕಿಂತ ಹೆಚ್ಚು ನಂದಿದೆ ಸರ್, my lord.
ಮಿಸ್ಟೇಕ್ ಏನಿದೆ ಅದನ್ನ ತೋರ್ಸ್ರಿ ಮೊದ್ಲು. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಇದೆ ಅಂದ್ರಲ್ಲ, ಏನ್ ಮಿಸ್ಟೇಕ್?
ಇಲ್ಲ, ಅದೇ ಬೇಕಿಲ್ಲ.
ಆಯ್ತು, ಅದೆಲ್ಲ ಇದು ರೂಲ್ಸ್ ಓದಿದ್ರಲ್ಲ ಇವಾಗ.
ಹಾ ಸರ್.
ಅದರಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ Are you required to submit the documents also?
Yes, ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ.
See, page number 39, 40.
ಆಯ್ಕೆ ಮಾನದಂಡಗಳು.
ಅರ್ಜಿಯೊಂದಿಗೆ ಪೇಜ್ ನಂಬರ್ 41. ಅರ್ಜಿಯೊಂದಿಗೆ ಲಗತ್ತಿಸಬೇಕಾದ ಅಪ್ಲೋಡ್ ಮಾಡಬೇಕಾದ ದಾಖಲಾತಿಗಳ ವಿವರ.
Yes, ma'am.
So you have uploaded the 9th standard marks.
Yes, ma'am.
Correct?
Yes, ma'am. Yes, my lord. Uploaded 9th marks ಮಾಡಿ.
Yes, if that is so, how can you find fault?
No, my lord.
Please see page number 41.
ನಾನು ಒಂದು ಮೆಮೊ ಹಾಕಿನಿ ಸ್ವಾಮಿ.
Along with the application,
ನಾ ಒಂದು ಮೆಮೊ
you are required to upload all the documents also.
ಪ್ಲೀಸ್ ನಾ ಒಂದು ಮೆಮೊ
So
ಹಾಕಿನಿ.
along with the application, if this person has uploaded the 9th standard marks
Please,
and that has been taken into consideration,
please, my lord.
what is wrong?
ನಾನು
Just because it's a typographical error.
treated the memo with along with the documents.
Yes.
Memo ಹಾಕಿನಿ. Sorry. Memo ಹಾಕಿ. Two documents, two mass card has to be show that, my lords. Two mass card has to be show that in applicant. ಅದರಲ್ಲಿ 2 mass card ಕೊಟ್ಟಿದ್ದಾರೆ. One mass card ನಲ್ಲಿ 8
application ಹಾಕಿದ್ದಾರೆ ನೀವು.
ಮೇಲೋಡ
ಇವಾಗ ಇಲ್ಲಿ ಹಾಕಿರೋದು ಅವ್ರ ಎಜುಕೇಶನ್ ಇಲ್ಲಿಗಲ್ ಇದೆ. ಎಂಟೈರ್ ಎಜುಕೇಶನ್ ಇಲ್ಲಿಗಲ್ ಇದೆ. ಮೈ
ಏನಂಗಂದ್ರೆ
ಇಟ್ ಈಸ್ 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನ ಶೋ ತೋರಿಸಿದ್ದಾರೆ. 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನ 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಶೋ ದಟ್.
Please come to page number 41.
ಪ್ಲೀಸ್
ಇಲ್ಲಿಂದ ಓದಿ ಹೇಳಿ ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಪೇಜ್ ನಂಬರ್ 41. ಅರ್ಜಿದಾರ ಲಗತ್ತಿಸಬೇಕಾದ ಅಪ್ಲೋಡ್ ಮಾಡಬೇಕಾದ ದಾಖಲಾತಿಗಳ ವಿವರ.
ಹೌದು.
ಈ ನೆವರ್ ಯು ಅಪ್ಲೋಡ್ ಮಾಡಿ.
ಏನು
ಅವ್ರ 9th ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರು ಪಾಸ್ ಆಗಿರೋದು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್. ಅವರು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಲ್ಲಿ ಪಾಸ್ ಆಗಿರೋದಿದೆ.
ಮತ್ತೆ ಎಲ್ರಿ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇಲ್ಲಿಂದ ಬರುತ್ತೆ ಮತ್ತೆ
ಅವ್ರದಿಲ್ಲ, ನಂದಿದೆ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್. ಅವ್ರದಿಲ್ಲ. ಅವ್ರು ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ. ನಂದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಬಂದಿದೆ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಹಾಕಿದ್ದಾರೆ. ಅವಾಗ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ರೇಂಜ್ ಮಾಡಿದ್ದೀನಿ. ಫಸ್ಟ್ ಕಾಲ್ ಫಾರ್ ಮಾಡೋ ಮುಂದ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಶೋ ತೋರಿಸಿದ್ದಾರೆ. ಅವಾಗ ನಾನು ಸುಮ್ ಕೂತಿದ್ದೆ. ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರನ್ನ ಆಡ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇವರು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ವೆರಿಫಿಕೇಶನ್ ಮಾಡೋ ಟೈಮ್ ನಲ್ಲಿ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ. 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ನ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈ ನೆವರ್ ಅಪ್ಲೋಡ್ ಇಟ್.
The authorities have said that they have uploaded. ಎಲ್ಲಿದೆ? where you get all this?
41 serial number 40 page number 41.
ಹೌದು.
ಅರ್ಜಿಯೊಂದಿಗೆ ಲಗತ್ತಿಸಬೇಕು.
That is what I'm saying. ಇದ್ರ ಪ್ರಕಾರ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಅದು ತಪ್ಪು.
ಹೌದು.
9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಮಾರ್ಕ್ಸ್ ಅಪ್ಲೋಡ್ ಮಾಡಿದೀನಿ ನಾನು ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ಇಲ್ಲ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ ಸ್ವಾಮಿ. 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ.
ಯಾವ ಮೆಮೊರಿ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ?
ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. ಮೆಮೊ ಡೇಟೆಡ್ ಇನ್ October 1 ಮೈ ಲಾರ್ಡ್.
ನೋಡಿ ಅವ್ರ ಹತ್ರ ಇದೆ, ತಗೊಳ್ಳಿ.
ತೋಳಿ 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡು. ಆಮೇಲೆ 2 ಮದರ್ಸ್ ನೇಮ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಪುತ್ಳಾಬಾಯಿ ಅಂತ ಬರೀತಾರೆ. ಆಮೇಲೆ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಲಲಿತಾಬಾಯಿ ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಪ್ಯಾಟರ್ನೇ ಚೇಂಜ್ ಇದೆ ಸ್ವಾಮಿ.
ಮೇಲೋಡ್ ಮೇಸಬಿನ್ ಮೇಲೋಡ್
ಎಂದು
ಯಾವ ಕ್ಲಾಸ್ ಇದು?
ಅದು ಒಂದು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇದೆ, ಒಂದು 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇದೆ. ಹೌದು. ಇನ್ನೊಂದು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ನನ್ನ 8th ನ 9 ತಿದ್ದಿದ್ದಾರೆ ಮೇಡಮ್. 8th ನ 9th ಅಂತ ತಿದ್ದಿದ್ದಾರೆ ಮೇಡಮ್.
ಇದಾ?
ಹೌದು, 2ನೇದು ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಂದ ಐತೆ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ.
ಆಯ್ತು. ದಿಸ್ ವಿಲ್ ಬಿ ಸೆಂಟ್ ಫಾರ್ ವೆರಿಫಿಕೇಶನ್.
ಹೌದು, ವೆರಿಫಿಕೇಶನ್ ಅವ್ರು ಮಾಡಿ ವೆರಿಫಿಕೇಶನ್ ಮಾಡ್ಬೇಕು.
ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ಮೇಲೆ ಅವರು They would have come to know, no, this is only 8 standard marks ಅಂತ. ಹೌದು. ಹಂಗಿದ್ರೆ ಅವರೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಇಲ್ಲ ಕ್ಯಾನ್ಸಲ್ ಇಲ್ಲ, ಅವ್ರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದ್ದಾರೆ.
ಹೆಂಗೆ?
9th
ವೆರಿಫಿಕೇಶನ್.
ಇಲ್ಲ 9th ವೆರಿಫಿಕೇಶನ್ ವಿತೌಟ್ ವೆರಿಫಿಕೇಶನ್ ನಲ್ಲಿ ಅವರು
ಇಲ್ಲ. No my lord, kindly see the
ಅವ್ರ
impugned
ಅಬ್ಜೆಕ್ಷನ್
order.
ಇಲ್ಲ, ನಂದೇ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
Impugned order ನೋಡಿ my lord.
After the verification of the BU, ಎಲ್ಲ ಕಡೆಯಿಂದ ವೆರಿಫೈ ಆಗಿ 9th ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಅಂತ ಇದು ಮಾಟರ್ ಜೆನ್ಯೂನ್ ಅಂತ ಅಂದ್ಮೇಲೆನೆ ಈಸ್ ಅಪಾಯಿಂಟೆಡ್ my lord.
ಕೈಂಡ್ಲಿ ನೆಕ್ಸ್ಟ್
Impugned order ನೋಡಬಹುದು my lord.
ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡಿ ಮೈ ಲಾರ್ಡ್ಸ್. ಅವ್ರದ್ದು ದಾಖಲಾತಿ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಪುತ್ತಳಾಬಾಯಿ ಅಂತ ತನ್ನ ತಾಯಿ ಹೆಸರಿದೆ. ಆಮೇಲೆ ಮಾಸ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಲಲಿತಾಬಾಯಿ ಅಂತಿದೆ. ಅವ್ರ ಎಜುಕೇಶನ್ ಜೆನ್ಯೂನ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಜೆನ್ಯೂನ್ ಎಜುಕೇಶನ್ ಅಲ್ಲ. ಅವ್ರು 8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಪಾಸ್ ಆಗಿರೋದಿದೆ.
Please don't go to that extent.
ಪ್ಲೀಸ್
ಅದು ನೀವೇ ಖುದ್ದಾಗಿ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡಿರೋ ತರ ಮಾತಾಡಬೇಡಿ.
ಇಲ್ಲ ನಾನು
Don't do that.
ಇಲ್ಲ, ಐ ವಿಲ್ ಗೋ ದೇರ್ ಇನ್ ಸ್ಕೂಲ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಐ ವಿಲ್ ಗೋ ದೇರ್ ಇನ್ ಸ್ಕೂಲ್. ನಾನು ಸ್ಕೂಲಿಗೆ ಹೋಗಿದ್ದೀನಿ. ನಾನು ಸ್ಕೂಲಿಗೆ ಹೋಗಿ ನಾವು ರಿಜಿಸ್ಟರ್ ತೆಗೆದು ತೋರಿಸ್ರಿ ಅಂತಂದ್ರೆ ತೋರಿಸಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಅವ್ರ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೋಡ್ಬೇಕಾದ್ರೆ 26 ಇದೆ, ಅವ್ರದ್ದು 18 ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ 26?
ಸೀರಿಯಲ್ ನಂಬರ್, ಕಾಲಮ್ ಸೀರಿಯಲ್ ನಂಬರ್, ಅಡ್ಮಿಷನ್ ಕಾಲಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಇರುತ್ತಲ್ಲ, ಅದು ಕಾಲಮ್ ಸೀರಿಯಲ್ ನಲ್ಲಿ 26 ಬಂದು ಮತ್ತೆ 18 ಬಂದಿದೆ.
ಸೊ
ಅದು ವೆರಿಫೈ ಮಾಡಿ ಅದು 26 ಆತರ 27 ಬರ್ಬೇಕು, ಅದು 18 ಹೆಂಗ್ ಬಂತು?
you could have got an endorsement.
ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ,
ವಾಸ್ಟ್ an endorsement.
ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ ಎನ್ಕ್ವೈರಿ.
9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಓದೇ ಇಲ್ಲ.
ಹೌದು,
8th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಓದಿರೋದು.
ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ತಗೋರ್ಬೋದಾಗಿತ್ತು.
ಇಲ್ಲ, ನಾನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ಆದ್ರೆ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಇನ್ annexure F 64
ಸರ್ಟಿಫಿಕೇಟ್.
ಹೌದು
ಸುಧಾರಾಣಿ, ಲಲಿತಾ.
ಹೌದು, ಮದರ್ ನೇಮ್ ಲಲಿತಾ, ಆದ್ರ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಪುತ್ತಳಾಬಾಯಿ ಅಂತಿದೆ.
ಸರ್ ಹಂಗೆ ಇವ್ರು ಓದೇ ಇಲ್ಲ ಅಂದ್ರೆ TC
ನೋಡಿ ಮಾ ಸ್ವಾಮಿ,
ಅವ್ರು ಬರ್ದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ 9th ಕ್ಲಾಸ್ ಬಿಡುವಾಗ ಅಂತ 9th ಅವರೇ.
ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಐ ಕೈಂಡ್ಲಿ ಸಿ ದ ರೀಡ್ ಇಟ್ ಇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೈ ಲಾರ್ಡ್.
ಅವರೇ ಹೆಂಗೆ 9th TC ಒಳಗೆ ಅವ್ರು 9th ಓದೇ ಇಲ್ಲ, ಸ್ಕೂಲ್ ಹೋಗೇ ಇಲ್ಲ ಅನ್ನೋದಾಗಿತ್ತಂದ್ರೆ TC ಅಲ್ಲಿ ಅವ್ರದ್ದು ಹೆಂಗೆ 9th ಸರ್ಟಿಫಿಕೇಟ್ ಮೇಲೆ ಮಾಡ್ತಾರೆ? ಒಂದ್
2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ ಸ್ವಾಮಿ ನಿಮ್ಗೆ.
ಎಲ್ಲಿ ಮಾಡಿ
2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ ಮೆಮೋನಲ್ಲಿ ನೋಡ್ರಿ. 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ.
ಎಲ್ಲಿ 2 ಮಾರ್ಕ್ಸ್ ಇದೆ ಹೇಳಿ?
2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್, ಇದು ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಬೇರೆ, ಅದು ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಬೇರೆ.
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ my lord, this is the marks card they are producing with along with memo my lord. See my lord, ಒಂದೇ ಸ್ಕೂಲ್ ಇಂದಿದೆ my lord, ಒಂದೇ ಸ್ಕೂಲ್ ಇಂದಿದೆ ಮೆಂಬರ್. ಅಲ್ಲಿ ಸೆಮಿಸ್ಟರ್ ವೈಸ್ ಇಂದ ಒಂದ್ಸಲ ತಗೊಂಡಿದ್ದೆ, ಇಯರ್ಲಿ ತಗೊಂಡಿದ್ದು 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಇದೆ. ಬೇರೆ ಸ್ಕೂಲ್ ತಗೊಂಡಂತ ಇದೆಯಾ? ಇದು ಎಲ್ಲ ಒಂದೇ ಸ್ಕೂಲ್ ಇಂದಿದೆ my lord.
Yes. Where is the
my lord, kindly see the impugned order my lord.
where is the
Page number 76 my lord.
76.
May I read my lord?
Printed format ಅಲ್ಲಿ ಲಲಿತಾ ಅಂತ ಇದೆ.
Yes my lord, admitted. ಒಂದ್ ಕಡೆ ಪುತ್ತಲಾಬಾಯಿ ಇದೆ, ಒಂದ್ ಕಡೆ ಲಲಿತಾ ಇದೆ my lord. I agree my lord. ಎರಡೂ ಒಬ್ಬರೇ my lord. ಅಲ್ಲಿ ಏನು ಬೇರೆ ಯಾರು ಇಲ್ಲ, ಒಬ್ಬರೇ ಅದರ ಮೇಲೆ.
ಅದನ್ನ TC ಬರೀತಾರೆ ಸ್ವಾಮಿ. ಮಾಸ್ಟರ್ಸ್ TC ಬರಿಬೇಕಾದ್ರೂ ರಿಜಿಸ್ಟರ್ ನೋಡೇ TC ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Whatever school authorities give is the correct information.
ಹೌದು,
You cannot merely because there are 2 names, ಅವ್ರು ಓದೇ ಇಲ್ಲ, ಅವರಲ್ಲಿ ಅವ್ರ ತಂದೆ ತಾಯಿ ಅಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ,
You can say.
ಅಲ್ಲ 2 ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಹೆಂಗ್
my lord,
verification sir.
my lord, ಪ್ರಸ್ತಾವನೆ my lord. In the impugned order page number 76 my lord.
76.
Yes my lord.
ಏನಿದು?
ಉಲ್ಲೇಖ 1 ಸರ್ಕಾರದ ಮಾನದಂಡಗಳ ಇಲ್ಲ ಇದರಲ್ಲಿ my lord, ಈ ವಾಟ್ ಆರ್ ದ ಪ್ರೊಸೆಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಡನ್ my lord. ಸರ್ಕಾರದ ಮಾನದಂಡಗಳಂತೆ ಆಳಂದ್ ಯೋಜನೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಕುದ್ಮುಂಡ್ ಗ್ರಾಮದಲ್ಲಿ ಖಾಲಿ ಇರುವ ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ಹುದ್ದೆಗೆ 2021-22ನೇ ಸಾಲಿನಲ್ಲಿ ದಿನಾಂಕ 30/6/2021 ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿ ಆಹ್ವಾನಿಸಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರಂತೆ ದಿನಾಂಕ 18/10/22 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕಲಬುರಗಿ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕಿಯರ ಆಯ್ಕೆ ಸಮಿತಿ ಕಲಬುರಗಿ ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಜರುಗಿದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕಿಯರ ಆಯ್ಕೆ ಸಭೆ ನಡೆಸಲಾಗಿತ್ತು. ಆನ್ಲೈನ್ ಸಲ್ಲಿಸಿರುವ ದಾಖಲಾತಿಗಳ ಆಧಾರದ ಮೇಲೆ ಹೆಚ್ಚು ಅಂಕಗಳ ಮೇರೆಗೆ ಶ್ರೀಮತಿ ಸುಧಾರಾಣಿ ಗಂಡ ಯುವರಾಜ್ ಅವರನ್ನು ತಾತ್ಕಾಲಿಕವಾಗಿ ಆಯ್ಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಸದರಿ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆಯಾದ ಅಭ್ಯರ್ಥಿಯು ಸಲ್ಲಿಸಿರುವ ಶಾಲಾ ದಾಖಲಾತಿಗಳು ನೈಜತೆಗೆಂದು ಕೂಡಿರುವುದಿಲ್ಲವೆಂದು ಆಕ್ಷೇಪಣೆ ಬಂದಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಸದರಿ ಶಾಲಾ ದಾಖಲಾತಿಗಳ ನೈಜತೆ ಕುರಿತು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆಯಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕ 15/9/2022 ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳು ಹುಮ್ನಾಬಾದ್ ಇವರು ಸದರಿ ಶಾಲಾ ದಾಖಲಾತಿಯನ್ನು ನೈಜತೆಯಿಂದ ಕೂಡಿರುತ್ತದೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ರಂತೆ ದಿನಾಂಕ 4/3/23 ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಜಿಲ್ಲಾ ಅಧ್ಯಕ್ಷರು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರ ಆಯ್ಕೆ ಸಮಿತಿ ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಜರುಗಿದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರ ಸಹಾಯಕರ ಆಯ್ಕೆ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಆಕ್ಷೇಪೆಯನ್ನು ಕೈಬಿಟ್ಟು ಶ್ರೀಮತಿ ಸುಧಾರಾಣಿ ಗಂಡ ಯುವರಾಜ್ ಅವರನ್ನು ಹೆಚ್ಚು ಅಂಕ ಆಧಾರದ ಮೇಲೆ ಹಾಗೂ ಆನ್ಲೈನ್ ಸಲ್ಲಿಸಿರುವ ದಾಖಲಾತಿ ಆಧಾರದ ಮೇಲೆ ಅಂತಿಮ ಆಯ್ಕೆ ಮಾಡಿರುತ್ತದೆ. ಮೆಲೋಡ್ ಆಲ್ ದಿಸ್ ಪ್ರೊಸೆಸ್ ಮೆಲೋಡ್ ಆಫ್ಟರ್ ದ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದ ಮೇಲೇನೆ to verify the genuinity of the document and reported by the BU and consider the same Melod appellant has appointed Melod.
Yes, my lords. Learned single judge just only gone on the only ground that
yes,
application only 8 standard ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. That is the only ground. ಅದನ್ನೇ main. It is
Melod on the that time Melod I am not appear before.
No, my lord. Application mention is online through with upload the documents. And upload and application also enter. Upload ಮಾಡಿನ ಬಾದೆ ಎಂಟರ್ ಮಾಡಿನ ಬಾದೆ ಅದನ್ನ ಅಪ್ಲಿಕೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಾಗಿದ್ದಿದೆ. ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಿದೆ. ನಾನು ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಇನ್ ಅನೆಕ್ಷರ್ ಎಫ್ ಮೈ ಲಾರ್ಡ್. ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಸ್
ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಏನಂತ ಹೇಳಿದೀನಿ, ಅನೆಕ್ಷರ್ ಎಫ್ ಪೇಜ್ ನಂಬರ್ 64 ಮೈ ಲಾರ್ಡ್.
ಎಸ್ ಓದಿ.
ವಿಷಯ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಮತ್ತು ಆಯ್ಕೆ ನಂತರ ಪಟ್ಟಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಕೈಬಿಟ್ಟಿರುವ ಕುರಿತು ಮಾನ್ಯರೇ ಶ್ರೀಮತಿ ಸುಧಾರಾಣಿ ಸೋಯಣ್ಸೋ ಕಮಲಾಪುರ ಸೋಯಣ್ಸೋ ಇದು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ನಾನು ಈ ಮೊದಲು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಾಗ ನನ್ನನ್ನು ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಆಯ್ಕೆ ಆಗಿರುತ್ತೇನೆ. ಆದರೆ ಸದರಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಆಕ್ಷೇಪಣೆ ಇರುತ್ತದೆ. ಸದರಿ ಅಭ್ಯರ್ಥಿಯು ಶ್ರೀಮತಿ ಸೋಯಣ್ಸೋ ಅವರನ್ನು ಬಂದಿರುವುದಿಲ್ಲ. ಇದು ದಾಖಲಾತಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಅವರ ಶಿಕ್ಷಣವು ಕೇವಲ 8 ತರಗತಿ ಮಾತ್ರ ಅಭ್ಯಾಸ ಮಾಡಿರುತ್ತಾರೆ. ಅದಕ್ಕಾಗಿ ಅವರು ಈ ಹುದ್ದೆಗೆ ಅವಶ್ಯಕತೆ ಶಿಕ್ಷಣ ಪಡೆದಿರುವುದಿಲ್ಲ. ಈ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ನಕಲಿ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ TC ಅವರ ವಿದ್ಯಾರ್ಹತೆಯು ಪ್ರಶ್ನಾರ್ಹವಾಗಿದೆ. ಅದಕ್ಕಾಗಿ ಸೂಕ್ತ ತನಿಖೆ ಮಾಡಿ ಹೆಸರನ್ನು ಪರಿಗಣಿಸಬೇಕು. TCಯಲ್ಲಿ ತಾಯಿ ಹೆಸರು ಸೋಯಣ್ಸೋ, ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ತಾಯಿ ಹೆಸರು ಸೋಯಣ್ಸೋ ಅಂತ ನಮೂದಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ನಾನು ಸೋಯಣ್ಸೋ ಸಮಿತ್ರ ಅವರು 9ನೇ ತರಗತಿ ಪಾಸ್ ಆಗಿರುತ್ತೇನೆ. ಪ್ರಯುಕ್ತ ನನಗೆ ಈ ಹುದ್ದೆಗೆ ಮೊದಲ ಪಟ್ಟಿಯಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಿದಂತೆ ತದನಂತರ 2ನೇ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ನನ್ನ ಹೆಸರು ಕೈ ಬಿಟ್ಟಿರುವುದು ನನಗೆ ಅನ್ಯಾಯವಾಗಿರುತ್ತದೆ. ಸೋಯಣ್ಸೋ ಮೈ ಲಾರ್ಡ್ಸ್. I will show that in that date has to be mentioned. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬಿಟ್ಟ ತಕ್ಷಣನೇ ಹಾಕಿದ್ದೇನೆ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು ಎಲ್ಲೂ ಇಲ್ಲ, ಅವ್ರು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು ಎಲ್ಲೂ ಇಲ್ಲ. ಅಪ್ಲೋಡ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಆನ್ಲೈನ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಾನು ಸಲ್ಲಿಸಿದ್ದೀನಿ.
ಮೆಲೋಡ್ ದ ಪೇಜ್ ನಂಬರ್ 73 ಮೆಲೋಡ್ ದೇರ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಮೆಲೋಡ್ ದ ಉಲ್ಲೇಖ 1ರಲ್ಲೇನೆ ಶ್ರೀಮತಿ ಸುಧಾರಾಣಿ ಗಂಡ ಯುವರಾಜ್ ಆಳಂದ್ ಇವರ ಆಕ್ಷೇಪಣೆ ದಿನಾಂಕ ಅವರೇ ಉಲ್ಲೇಖ ಮಾಡ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಮೆಲೋಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Page number 73 Melod, kindly see.
By order dated 7/7/2023, please, you are appointed. Please.
Yes, Melod.
7/7/23.
Yes, 7/7/23 Melod.
ಅಲ್ಲಿಂದ ಈ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋವರೆಗೂ ಯು ಹ್ಯಾವ್ ಫಂಕ್ಷನ್ ಆಸ್ ಎ ಅಂಗನವಾಡಿ ವರ್ಕರ್.
ಪ್ಲೀಸ್ 1 year ಮಾಡಿದ್ರು.
ಕೆಲಸ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದಾರೆ.
ಕೆಲಸ ಮಾಡಿದಿರೇನ್ರಿ?
ಎಸ್ Melod.
1 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದೀರಾ?
ಮೊದಲು ನಾನು ಅಲ್ಲಿ Melod.
ನೀವೇ ಕಣ್ರಿ, ನಿಮ್ನೆ ಕೇಳ್ತಾ ಇರೋದು.
ಎಸ್ Melod.
1 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದೀರಾ?
ಎಸ್ Melod.
7/7/2023 ಆರ್ಡರ್.
ಎಸ್ Melod.
ಅದ್ರ ಪ್ರಕಾರ ಈ ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ಮಾಡೋವರೆಗೂ ಯು ಹ್ಯಾವ್.
ಎಸ್ ಐ ಆಮ್ ದ ಕಂಟಿನ್ಯೂ. ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನಾನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಎಸ್
Melod, ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಪರ್ಫೆಕ್ಟ್. ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ತಾನೆ?
ಎಸ್ Melod, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಆಗಿದೆ.
ಆಗಿದೆಯಲ್ಲ?
ಎಸ್ Melod.
Learned counsel for the appellant submits that the learned single judge has passed the impugned order only on the ground that the applicant had admittedly written in the application form that she has passed 8th standard. And therefore, there was no occasion for the respondent authorities to consider her 9th standard marks. Full stop. However, learned counsel submits that in terms of the requirement of the notification governing recruitment of the Anganwadi workers, along with the application, the applicants are required to upload all the information, including the marks card. Full stop. Having regard to the said information given by the petitioner, appellant, and on consideration of the objections raised at the ends of the 9th respondent herein, please. Yes. The Deputy Director third respondent, Deputy Director, Women and Child Development, Kalaburagi, passed an order on 7/7/2023, very clearly stating that the school records of the petitioner got verified and they were found genuine. Full stop. Learned counsel submits that a typographical error had occurred in the application form, where the educational qualification of the petitioner appellant was shown as 8th standard. Full stop. However, the 9th standard marks card were uploaded along with the application. Full stop. Therefore, there was no doubt with the authorities that the petitioner had passed 9th standard, which was the minimum requisite qualification. Full stop. Moreover, the appellant has started working from 7/7/2023 till the impugned order was passed by the learned single judge. Full stop. Next para. Consequently, there shall be an interim order of stay of the impugned order dated 26th of June 2024. Full stop. Next para. Learned government advocate is directed to secure and place before this court all information secured by the Deputy Director of Women and Child Welfare, Kalaburagi, before passing the order dated 7/7/2023. Release this matter on 19th of November. Please, much.
Bill number 48, B group matters.
ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಏನಪ್ಪ, ಅಂಗನವಾಡಿ ಅಸಿಸ್ಟೆಂಟ್ ಇದು?
ಅಸಿಸ್ಟೆಂಟ್ ಟೀಚರ್. ಇದು ಬಂದಿಲ್ಲ.
Yes.
Seal number 48, Mahantesh Patil.
B group. ಇದೆಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು.
Sorry to make a mention, Miller. Serial number 40. Sorry, Miller.
Yes.
Not be present when case is called. 44. 44 Miller. 44. ಅದು ಕಳ್ಸಲ್ನು ನಾನು ಬಂದಿಲ್ಲ ಅಂತ ಆಗಿತ್ತು, ಯಾಕೆಲ್ಲರೂ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. 44. ಐ ಆಮ್ ಸಾರಿ ಟು ಮೇಕ್ ಎ ಮೆನ್ಷನ್ ಎಟ್ ದಿ ಫ್ಯಾಕ್ಟ್.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
My lord, 59. My lord, 59 interim.
Number 56.
Interim order is there.
Date ಕೊಡ್ತಾರೆ, interim order will be extended.
Serial number 54, you will.
Maybe listed on 7th, my lord. Serial number 49.
Date click.
Serial number 54, you will.
Court officer Suresh, namaskara.
ಒಂದೇ ನಿಮಿಷ ಸರ್ ಹೇಳ್ರಿ.
ಸರ್ ಅದು 22nd ಗೆ ಕೊಡ್ಬೋದಾ ನಂದು 56?
56
ಹಾಂ ಸರ್.
56 ಯಾವಾಗ ಬೇಕು ಸರ್ ಇದು?
22nd.
22nd.
ಹಾಂ ಸರ್.
ಆಯ್ತು ಸರ್.
23rd ವರ್ಕಿಂಗ್ ಐತಿ ಸರ್? 23rd ವರ್ಕಿಂಗ್ ಡೇ ಐತಿಲ್ಲ?
ಬೇಡ, ಅದರ್ ದನ್ ಫ್ರೈಡೆ ಯಾವ್ದಾದ್ರು ಡೇ ತಗೋರಿ. 22nd ಫ್ರೈಡೆ ಆಗ್ತದ.
ಹಾಂ ಸರ್.
ಅದರ್ ದನ್ ಫ್ರೈಡೆ ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದಾದ್ರು ತಗೋರಿ.
ಹಾಗಾದ್ರೆ 25th ಕೊಡಿ ಸರ್. ಹಾಗಾದ್ರೆ
25th
25th.
ರೈಟ್ 25th.
ಹಾಂ ಸರ್.
ಎಸ್ ಸರ್ ಆಯ್ತು.
ಎಸ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
49 7th week.
ಹಲೋ.
ಆಯ್ತು. ಓಕೆ ಹೋಗ್ಬೇಕು. ಫೋರ್ತ್ ಬಿಡ್ರಿ. ಓಕೆ ಯಾವ್ದಾದ್ರು 54 ಇಲ್ಲ, ನಾವು ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ನಮ್ ಡೇಟ್ ಕೊಡೋದು ಡೇಟ್ ಕೊಡ್ತೀವಿ. 54 5th 54 55 ಆಲ್ಟರ್ನೇಟಿವ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬೇಡ. ಯಾವ್ದು 55 ದಲ್ಲಿ 5th 54 55 ಇನ್ನೊಂದು